Welcome to this licensing subcommittee today. We're welcoming everyone to today's reconvened meeting of the licensing subcommittee, adjourned on 9th of December 2021. Just a bit of housekeeping. If the fire alarm is activated, please take the stairs down to the reception area and out of the building to the green in Hawley Square, which is the assembly point. Please do not use the lifts. Officers will assist you and advise when it is deemed safe to return to the council offices. Filming of the meeting. I would advise that if filming takes place, anyone in attendance in the public areas may have their image captured. I urge anyone filming proceedings to avoid filming members of the public, particularly if there are children present. Does anyone intend to film the meeting? No? So nobody's going to film it. Okay. Would everyone present please ensure that their mobile phones are turned to silent and that they are not used to make or receive phone calls whilst this meeting is in progress. Apologies for absence. Are there any apologies for absence?
No apologies, Chair.
Okay, thank you. Declarations of interest. Are there any declarations of interest? Okay, agenda item 3, application for a full review of the licence for Faith in Strangers, 17 Ethelbert Crescent, Margate. I call upon Ms Phillips, the Council's Principal Litigation Solicitor, to explain to the parties the procedure that we will be taking during the hearing.
Thank you. Good afternoon, everyone. I'd like to confirm that the decisions of the subcommittee are made in accordance with the Licensing Act 2003 and are based on the information that's presented in this agenda, together with any verbal submissions that's made today. The decisions of the subcommittee, they're not politically based, and the subcommittee will act impartially and offer a fair and unbiased hearing of today's application. As the Chair said, the hearing today is of the Licensing Subcommittee, which was adjourned on the 9th of December 2021 for the application for a full review of the licence held by Faith in Strangers, who are situated at 17 Ethelbert Crescent, Margate, which was made by the Licensing Department to Thanet District Council as the relevant licensing authority in accordance with the Act. We will hear the parties in the following order. First, we will hear Alison Brooke, who is the Licensing Technical Support Team Manager, and she will present a report. Secondly, we will hear from the Environmental Health Department, who are represented today by Mr. Ranatunga, and he will be given up to 25 minutes to address the subcommittee on behalf of the Environmental Health Department. Then we will hear from the interested parties, who include members of the public who have submitted representations. We will hear from Mr. Rees-Gay of Wood Were for the residents who have submitted their representations, and he will have up to 25 minutes also to make representations. There will also be representations from residents who have submitted representations, and then lastly from Sarah Clover, who is representing Faith in Strangers. Now, after each person has made their representation, each of the parties will have an opportunity to ask the individual questions, and members of the subcommittee also will have an opportunity to ask questions. In summing up, after all the representations have been made and questions answered, and each representative will be allowed 5 minutes to give a summary and to make any final representations. Once all the relevant representations have been made, the subcommittee, the Democratic Services Officer, and myself as the legal officer will leave the chamber and go into another room to deliberate and come to a decision on the application. And this should take around 30 minutes, after which we will return back to the chamber, whereupon I will announce the determination of the subcommittee.
Madam Chair.
Ms Clover?
May I be permitted to address you, Madam Chair, on a legal point? It has been notified in advance to your legal advisor, and I've mentioned it this morning to this afternoon, to Mr. Rees-Gay and Mr. Ranatunga. I have indicated that this hearing is not vires, it is ultra vires, it is not lawful under Section 52 of the Licensing Act 2003. I've also made some written submissions in relation to the locus, the ability to address you of the environmental health team represented by Mr. Ranatunga and Ms. Berry. This is because the review application has been withdrawn, formally withdrawn. The representations from third parties that have come in within the statutory time period are parasitic upon the review application. And Section 52 of the Act is very clear that where there is an application for a review, a hearing must be convened, and in several places in the section it refers to the hearing considering the application and the relevant representations. They are cumulative. They stand or fall together. And this point was raised at the very inception of the Licensing Act back in 2007 or 2008, and I have the quotation here, with lay cause, which was the legal advisory agency to DCMS, the Department of Culture, Media and Sport at the time, who had the remit for licensing. They were asked this question. They answered in this way. So it was actually August 2007. Lay cause recently received a query regarding whether it's legally possible to withdraw a review application, and if so, how should local authorities deal with any representations that have been received in respect of the review? Following discussions with the DCMS, Lay Cause is now able to offer the following commentary on this issue, that although there is no express provision in the Act for withdrawal of applications, it should nevertheless be possible for applicants to withdraw any application should they no longer wish to proceed. And since the provisions of the Act are drafted in the same terms for grants, variations and reviews, this withdrawal mechanism must be applied consistently, so it would be applicable to reviews. Once the application is withdrawn, legally, nothing remains to sustain the representations, and therefore no hearing would be required. I've set this out in writing. The relevance that it has is that in the event that this hearing goes ahead anyway, and I anticipate you'll be hearing opposite representations from the other legal personages in the room, but if the hearing goes ahead anyway, there is technically no right of appeal to the Magistrates' Court, because an ultra vires hearing does not trigger any right of appeal within the magistrates, and it would therefore have to be taken in accordance with the legal analysis to the High Court on a judicial review. I have to say this now, therefore, to put the decision makers, the putative decision makers, on notice before they start to do what it is they think they're going to do, because it may result in JR proceedings. Thank you.
Thank you, Ms. Clover. I'll need to consult with our Principal Litigation Solicitor, Ms. Phillips.
Madam, I don't know, it's Mr. Ranatunga here on behalf of Environmental Health. I can address you on that legal point if you so wish, but I know you've taken legal advice.
No, if you'd like to go ahead. That's fine.
I'm grateful. In short, Madam, my position is that the point that's made is wrong, and it's for these reasons. What we know has happened in this case is that there has been an application made by Environmental Health. That has been consulted upon in the normal way. There's no objection to that process carrying through in the normal way, and representations have been made. It is right to say that in writing on the 2nd of December of last year, Environmental Health indicated that they had taken a decision to withdraw the application for review. But following that consultation taking place, and following the receipt of the application, this committee is seized of the application. And this is public interest applications under the Licensing Act 2003. And you are entitled, in fact you must, continue to hold the hearing to hear what residents and other people who've made relevant representations have said. So that is the position. The particular point, to get into the legal niceties of it, raised by Ms Clover, is under section 52. And as I understand what's said, section 52 is about the determination of applications for review. Subsection 2 states that before determining the application, the authority must hold a hearing to consider it and any relevant representations. And I suppose the subtlety of the point that Ms Clover raises is to say, well, firstly, you must hold a hearing, and that's my point. But she says to consider it, i.e. the application, and any relevant representations necessarily means that if the application is withdrawn, there's nothing to consider. Well, that can't be right, in my respectful submission. You must hold a hearing to consider both it, I would interpolate, and any relevant representations. In the absence of the application itself, i.e. we've decided to withdraw it, you still in fact have received an application, you still received relevant representations about the issues that we're dealing with today, which is noise from the premises, and you must hold a hearing to consider them. Now, that is my position on the interpreting the statute. If I needed assistance on that, the leading practitioner's text in licensing is Patterson's, and it has footnotes on various matters, one of which is engages with this issue. And I think all the advocates will be aware of the commentary to section 52 and what it says, but footnote 1, since it's been raised, does refer to the situation where, for whatever reason, the applicant for review no longer wishes to pursue it and says that it's withdrawn. In those circumstances, the editors of Patterson's, and of course this is a practitioner's text, nothing more, but they say the obligation on the part of the licensing authority is to hold a hearing. For all the reasons, really, I would suggest I've outlined. Now, what Ms Clover does raise is the lay cause guidance, and I have seen an email sent by Ms Clover to that effect, and she does refer to what an officer at Lay Cause had commented in 2007. So just to put that in context, that is not statute, that is not an authority from the courts, that is not statutory guidance. It's what one officer at Lay Cause has commented may be the position following that issue being raised in 2007. It does not have any particular status before you. It is an observation. Even if that officer got the law right, and I contend that he didn't, what he says is that once the application is withdrawn legally, nothing remains to sustain the representations. Therefore, no hearing would be required. Even on Miss Clover's case, it's a discretion. And the question you have to consider is, given where you are, you must hold a hearing, is what the Act says. There are relevant representations following a proper consultation period, and you are seized of the application. Even if Ms Clover's right as to what the law is following what Lay Cause say, it appears to suggest that there's a discretion to hold the hearing. So even on that basis, I say this hearing should go ahead. The position to say, well, there would be no right of appeal is neither here nor there, because if you decide to proceed with this hearing and you come to a decision, then Schedule 5 of the Act applies in the normal way. You've made a decision, it is appealable within 21 days to the magistrate's courts, and there would be a de novo hearing. I say for all those reasons, you should proceed to consider the hearing. I am also finally aware that I think Ms Phillips, your legal advisor, did comment on the position at an early stage and understood that the hearing was to go ahead. So as I understand it, I'm on all fours with that.
Madam Chairman, just a correction there. This wasn't a single office within Lay Cause. This was the mouthpiece for the government department.
Chair, if I could just add on behalf of the residents. I feel ambushed. I'm not aware of any of this before, and obviously I've just received 290 pages of paperwork thinking that this hearing is going ahead. I agree entirely with what Mr Ranatunga has said in terms of this hearing must go ahead today, and just disappointed. Obviously, I understand Ms Phillips may have been aware, but I certainly haven't been, and feel desperately ambushed that I'm unaware of this, and that was the position of Faith in Strangers. But would support Mr Ranatunga's view entirely, go with Patterson's, and the hearing must go ahead, please.
Okay, I've consulted with our litigation solicitor and we will be going ahead with the meeting as planned. So moving on.
Madam Chairman, forgive me. There is another supplementary point. We have received correspondence either from Miss Berry or on behalf of Miss Berry to indicate she won't be making any representations to the committee. I'd seek some clarification on that, because we did say at the beginning the council was going to go first. That can't be right.
I don't know again,
Ms
Madam.
Clover, Ms Berry's not making any representations, she's just introducing. Who's, oh, is it Ms Broadlands who's introducing?
Madam, I don't know if I can assist again on that point. What you have is Alison Brock, who is the licensing officer in the case, who's going to present the report. And then environmental health are here. Amanda Berry sits next to me. She's the senior environmental health officer who brought the review. My position, I believe this has been, I represent environmental health. My position, I think this has been set out in writing, is to explain what the review was, but also to explain our position, which is the reasons really why we withdrew the application. We are here to assist the committee nonetheless, and I do hope to update you on our position. The application for review remains withdrawn. It was withdrawn on the 2nd of December, but as you can well appreciate, I imagine, things do move on. I'm not reinstating it in any way, but I am here to assist the committee if you have any questions and to update them and to explain the reasons for withdrawal.
Madam Chair, forgive me. This is very important because Mr Ranatunga has just indicated that he intends to update you on more recent matters. That cannot be. From a legal perspective, Miss Berry does not have any locus standi in front of the committee because the application has been withdrawn. She didn't put in a representation within the representation period, so technically she is not here. And although Mr Ranatunga represents her, he can only be her mouthpiece, and technically he's not here either. I was told in an email that she may answer some questions from the committee as to why the review was withdrawn, but it's still all within your agenda. And if the committee is going to be relying upon a withdrawn review that has been taken away and looking at it and looking at complaints that were made and looking at things that were said and looking at file notes and what have you, that again is unlawful because you're looking at something that has been withdrawn from your attention.
Chair, Sorry, Chair, if I could assist. In the hearing regs at 17, it says members of the authority may ask any question of any party or other person appearing at their hearing.
That's the point. That's the point. She's not a party or a person appearing.
Sorry, Ms. Clover, I was speaking. Mr Ranatunga and Miss Berry are here. Should it be a difficulty, I will be relying on the evidence that they put in. But my view, certainly representing my clients, would be that Miss Berry is able to speak. I don't know if Mr Ranatunga's got a view on that at all.
Just if I may, one point that we've been clear in writing, 13th of January of this year to the premises, although the review application is no longer being pursued, the Environmental Health Department will be attending the hearing to assist the committee as to the reasons for not pursuing the application and to explain its position. Now, as part of explaining its position, so that I think has been made clear, and insofar as we're present as under Regulation 17 or otherwise, we're here to assist you. And you did receive an application. You are seized of it. It is before you, although I am not pursuing it, and we have taken a decision that we've withdrawn it. Insofar as that's concerned, I will be, if I'm given the opportunity, updating you on our current position. But I am not pursuing the review application that we put in. As at 2nd of December, we indicated that that's withdrawn.
Would the technical support team manager please present the report?
Good afternoon. This hearing has been reconvened from the adjourned hearing that was originally held on the 9th of December 21. At the hearing in December, the subcommittee decided to adjourn the meeting at the request of the barrister representing Faith in Strangers so that the matter could be considered at a later date. The subcommittee is now requested to consider the application and make any recommendations they feel appropriate. Thank you, Chair.
Thank you. Mr Ranatunga, would you please address the board on behalf of the Environmental Health Department? Up to 25 minutes.
Thank you, Madam. And what I propose to do is just refer you to the papers that you had and then update you in two respects, really. The first is the reasons why we withdrew that application. It's right that you know that, and this is a public hearing. And then to update you on any matters arising since that in my submission are relevant. You'll be familiar that the licensing objectives are the matters that you must promote in this hearing, and the one that clearly is engaged is the promotion of the prevention of public nuisance, and that is what under the Act you must promote, which is what your decision will ultimately be based upon. I just want to touch upon the review application that was lodged, just to give you the background before coming to the reasons for withdrawal and then dealing with other matters. I know that you will have seen a lot of papers in this case, but the review application is at page 9 of the original agenda, and you'll see that that was lodged by Amanda Berry based on the prevention of public nuisance. The grounds for review are under pages 12, 13 and 14, and it's right to note that what occurred here is that following the grant of a licence in August 2018, a premises licence under the Licensing Act 2003, Environmental Health received complaints from around October 2019, and you'll see on page 13 there was then of course COVID, which intervened for a period from 2020 through to May 2021, and then further complaints received. I just want to pick out a couple of points just to give you the context. The top of page 13 makes plain that noise complaints were made to Environmental Health. 5 were from separate households within Cliftonville Court, and you'll, I hope, be familiar with the area and the surroundings. And it goes on to say that visits in the normal way were conducted by Environmental Health and refers to out-of-hours visits. Firstly, there was a visit, I think a planned visit on the 11th of June 2021. Then a complainant called the out-of-hours nuisance control service on the 10th of July at around 11 o'clock. And then noise recording equipment was installed, and an officer assessment was carried out on the 18th of September, Saturday the 18th of September. And finally, on the last paragraph on that page, a noise recorder was installed in September, 24th to the 27th, and officers were called out to witness the noise on days in September and October. In all instances, loud music could be heard. The application went on to refer to a degree of entertainment, music, noise from amplified equipment, and that a degree could be or had to be tolerated to achieve a balance, but that this had gone beyond that. And what it sought was licence conditions to be imposed on the licence, and you'll see those on page 14. Firstly, the removal of what's known as the Live Music Act exemption. It's only on a review that you can impose noise type conditions because of the Live Music Act deregulation up to 11 o'clock. For certain types of premises. A noise limiting device was suggested, and levels were suggested up to 11 o'clock, and you'll see the first of those, LAEQ, so the level is A-weighted, equalised across a period to 81 decibels. And just to note that the reason why those levels were set, perhaps for your legal advisor's note, but also for you, Madam, and your colleagues, page 66 of the same bundle refers to measurements taken at the premises with an officer stationed in a complainant property and music played, and they gauged the levels that they thought would be appropriate. up until 11, and that's why that is included in that condition. Then thirdly, all live and recorded music to be stopped at 11 p.m. And all tables and chairs to have rubber socks fitted to the legs. And to be clear on that, there was an issue with the movement of furniture, and it's right to say that the premises did put some rubber stops on some of the furniture. It doesn't appear to have resolved the issues, and that's why it was included in the review. And then hand dryers not to exceed 80 decibels LA max. That was because of the noise that comes from hair dryers. That's obviously when music was taking place at the premises. It would actually be lower, actually 55 dB max is what would be sought as part of that condition if there was no music playing. So it was conditions that were sought. And the basis for that application is, as I've outlined, and you'll have seen a number of relevant representations that came in from others. Now, that is the review application as was lodged. It is right and proper that I indicate that on the 2nd of December, the Environmental Health Department wrote to the premises, but also around then, I think, to residents who'd raised complaints, saying that they'd taken the decision to withdraw the application for a licence review. Now, there's also in the background a noise abatement notice that had been issued. We're not here dealing with that, and I don't wish to take up time talking about that point, but that was also withdrawn. What was the basis for that? So I need to just explain what our reasoning was. On further scrutiny of that evidence which they'd gained through that investigation, Environmental Health determined that the principal reason for bringing the review was the transfer of entertainment noise, i.e. amplified music, and whilst in officers' view, the impact on one of the flats, now that's flat 3, was something that would have an impact on the ability to sleep, and therefore clearly an issue that needed to be dealt with. That was not considered to be a class or community of people, and therefore not a public nuisance. Now, that is a particular view taken of what public nuisance is. Public must be more than one person, is the view that officers took. And they had only been able to verify that there was a particular issue with one flat. And because of that, and notwithstanding that that was a real and verified issue, they did not feel that was public nuisance because it didn't affect more than one premises. Now, I've already addressed you on the fact that there were complaints from, I think, 5 different premises. The position on that is either those other premises had not invited Environmental Health in to verify their concerns, or if they had, what Environmental Health officers had heard did not, in their view, constitute a public nuisance. So the levels were not high enough to be a concern. So those were all of the reasons as to why Environmental Health took the decision to withdraw the application. Now, for all the reasons I've already outlined, that application remains before you. It's been consulted upon. You've received relevant representations. You've decided to continue, as I think you must, to have a hearing to consider them. And so the point to make here is we're now at 17th of February 2022, and things move on. This Environmental Health Department still has a duty to investigate complaints. It still receives complaints. And it's right that I just update you on that.
Madam Chair, I make a formal objection to it. It hasn't been notified. I've got no prior information as to what Mr. Ranatunga is about to say. He has just effectively presented the review application to you, which was withdrawn, but this is completely new, and I'm relying on Regulation 18.
I'm not submitting any documents to support this. Insofar as I refer to anything, insofar as I refer to anything, they are letters that the premises has received. We've been perfectly open and they're not without prejudice. They're letters in the normal way. If we receive complaints, we follow up on them and we write to the premises. And I wish to address you on, firstly, the withdrawal. I've talked about that already.
Madam Chair, I'm going to ask the committee to make a formal decision about this with reasons on the basis of Regulation 18. I don't know what letters Mr. Ranatunga is talking about. I'm representing the premises. I haven't been put on notice of anything additional that is going to be presented today. I know nothing about it. In terms of Regulation 18, No information, and the word is information, shall be presented to the committee at the hearing if it hasn't either been notified in advance or with the consent of all the parties, and I don't consent.
Mr. Ranatunga, if I could assist, that correspondence is actually in my bundle, the letters to Amanda Berry on the 2nd of, so it is in front of the committee.
So the letters have been mentioned, but the details of the letters haven't been discussed, so it doesn't fall under Section 18, so it doesn't fall foul of Section 18.
I don't know what he's going to say, so I can't answer that.
Well, the answer there is, hear what I have to say. If there's still a concern, you can take a view, and Ms Clover, I'm sure, will make the point.
Fine, yes, go ahead.
The Environmental Health Department, in its withdrawal letter, which I've already referred to, actually said, given evident disturbance experienced by occupants within flat 3, we sincerely want to find a solution. And ultimately, that's what the Licensing Act is about. And they said that even in the same breath as saying we're withdrawing the application for the reasons we've outlined, they did say we want to find a solution. There have been 3 further letters sent to the premises which raise concerns. And the first is the 13th of January 2022, sent to the premises. Can't be any prejudice in relation to that. And it makes clear that, as we understood it, the hearing was going ahead. We had a duty to investigate noise complaints, and we asked the premises to address the hand dryers issue, the movement of furniture, details of the acoustic consultant that was engaged, consider installing a sound limiting device. All of those were points that had been raised already and we say just needed to be dealt with. The second letter which we sent, 31st of January 2022, further to the letters of the 2nd of December, which was the withdrawal one, and the 13th of January, we requested an update on what steps were being taken to minimise noise transmission to residents in the adjoining Cliftonville Court. It advised specifically that Environmental Health had received 2 further complaints about noise from the premises on the evening of Saturday the 29th of January. The complaints came from separate households on the 4th floor of Cliftonville Court. Although the complaints were not substantiated by council officers, i.e. they couldn't go in at the time and say this definitely happened, I'm deeply concerned, says Amanda Berry, that noise may be now pervading into 4th floor flats, and asks you to ensure that the levels previously recommended are not exceeded. And then the final letter is the 9th of February 2022, headed Ongoing Noise Complaints. Further to my most recent letter, so 31st of January, I'm writing to update you regarding complaints. As you're aware, complaints have been made to Environmental Health in relation to Saturday the 28th, it says, but it should be the 29th of January. Residents were offered available services to enable their complaints to be investigated further. Noise recorders and measurements were taken from within 3 flats on the 2nd, 4th and 5th floors on Saturday evening. The measurements suggest noise levels were well in excess of those previously recommended. And just pausing there were levels in the review application, which I've referred to, the 81 dB, which were those that were measured. The measurements suggest noise levels were well in excess of those previously recommended, around 18 decibels louder, with low-frequency bass music plainly audible in a 4th floor bedroom and just perceptible in the 5th floor. I appreciate you will not be formally responding to this information at this stage, but want to keep you appraised of further information. And just pausing there, that's really what I'm doing. These things do move on. It is right to say, and it's formally correct, we withdrew the application, but I'm here to assist you and to update you on the current position. And it is right to say that following the withdrawal, we've sent 3 further letters and had no meaningful response. The response we've had from the premises is to say that they've taken legal advice and they won't be engaging with us for all the reasons that I think Ms Clover has outlined. I'm here to say that Environmental Health, notwithstanding their withdrawal, have received complaints, remain concerned. There is fundamentally an issue with noise from this premises that needs to be addressed, you may feel. I'm not pursuing the review application, but in assisting you, I wish to draw all of this to your attention.
Thank you, Mr. Ranatunga. Mr. Rees-Gay, do you have any questions for Mr. Ranatunga?
Sorry, Mr. Brandt, I just wondered, was there a reason why another adjournment wasn't sought rather than just withdraw? Because obviously the sentiment of the residents was, you know, it was never discussed. I just wondered if there was any light could be shed on that at all.
I think the decision was taken, having reviewed the evidence as they had it at the time, that it didn't constitute public nuisance, and the other evidence that was there did not engage that, and therefore it was withdrawn.
Thank you. And I suppose a rather pointed question. Obviously, my clients came to you in good faith. Obviously, you are the responsible body for dealing with noise, and yet it was withdrawn. I don't think at any stage you were told you couldn't go into other areas within the development, as it were. Is there any reason, obviously, that wasn't done? Obviously, these guys understand that they were the focal point as the head of resident association at that time, and obviously offered their flat. Was there any reason? Obviously, it's that issue that can't quite be understood.
So my instructions are that we did follow the normal procedure by which we did say that we could visit some of the residents. Some took that invitation up, some didn't, and certainly flat 3 we did. I think there were others, but there were others who didn't take up that invitation, and those that did take up the invitation apart from flat 3, we did not think the levels were such as to engage the public nuisance licensing objective, which left us with flat 3, which is one property, and therefore, in our view, as at the 2nd of December, I should be clear, as at the 2nd of December 2021, we did not feel that constituted a public nuisance.
Thank you.
Sorry. Is it? Okay. Do any of the residents who submitted representations have any questions for Mr. Ranatunga?
I'm just mindful that when we say that the call-out service was available to other residents, that was made available to other residents in September, and that I think it was withdrawn the following month due to budgetary constraints. So,
Madam Chair, could we identify who's speaking, please?
oh, I'm sorry. I'm Beth Pritchard. I'm a resident. Sorry. I'm chair of the Residents Association, and I'm also a resident of Flat 3, which is the most affected flat.
Amanda Berry, Environmental Health Officer. I believe it was the nuisance call-out service was also issued to 2 other flats in August, to clarify.
Craig McKinley?
Thank you, Madam Chairman. I'm here on behalf and probably appointed by Charlene Bryant of Number 1. Yeah, if I could ask Mr. Ranatunga, the abatement notice that was properly served on the 23rd of September 21 is page 71 in the pack. I didn't quite get the reason as to why that was withdrawn, because the issuance of that and the proper service would have given you quite a number of powers, not least under the Environmental Protection Act, to take court action. Why was that withdrawn?
Thank you. So just to be clear, that was also withdrawn by the letter on the 2nd of December 2021. we're not formally here dealing with that, but I will address it because of the question that's been asked. You may be familiar, under the Environmental Protection Act 1990, one of the matters that you have to consider, I mean, firstly, there's an obligation to consider whether or not there is a statutory nuisance, and officers felt there was, but in making that decision, you do have to consider what's known as best practicable means and all of the various circumstances surrounding an individual premises. That's the location, character of the area, and also the background. And the background in this case includes a planning permission which was granted, and a sound insulation condition, and the history which you'll presumably be hearing about, but is in the papers about it being a nightclub in the past, as well as the levels observed by officers. And all of those matters should have been taken into account when the decision was taken to issue the noise abatement notice. Some of them were not. And so the decision was taken on the 2nd of December to withdraw that as well. That's not to say that under the 1990 Act we still don't have a duty to consider the position on an ongoing basis, but there is no noise abatement notice before in existence.
Do any other residents have any questions?
May I make one more observational question? Could I ask just for confirmation that the call-out service, what time it closes?
The nuisance control service typically operates from around June through to November, mid-November, and when it's in operation, it's from 7 p.m. until midnight on a Friday and a Saturday evening.
I only raised that question because being a nightclub, often the noise is loudest after midnight, which is part of the reason why residents may not have called out the service.
Thank you.
Yes, I'd like to. This is
What's your name?
Jacqueline Davis, flat 11, owner-occupier. You say the service was withdrawn. What about the residents' side of this? You know, I mean, a public nuisance is a public nuisance, which I don't think it's the building, not one flat per se, is not a public. Sorry, I've been.
Are there any other questions from the residents?
Obviously not at the moment. Thank you.
Does Mr. Clover have any questions for Mr. Ranatunga?
Yes, thank you, Mum. Just picking up on the points you've made about the noise abatement notice, Mr. Ranatunga, you've indicated that Environmental Health are under a continuing duty to investigate noise nuisance, but the reasons for the withdrawal of the noise abatement notice you've indicated as being at least threefold, one being the grant of planning permission, the second being the history, including Frank's nightclub, and the third being best practicable means. Those are not going to change, are they?
Well, the grant of planning permission and the history are both aspects of best practicable means, but officers have a continuing duty to investigate noise complaints in their area, and if they form the view that something amounts to a statutory nuisance and that best practicable means is not, in the event, available, they can still issue a notice. It's not something I wish to constrain for anyone, any future officer, seeing it as they see it. The fact of the matter is they have to be taken into account. That's not the same as saying they always indicate the same outcome.
Just to be absolutely clear about what we mean by best practicable means under the 1990 Act, that is to say that the premises have done everything that they can, yes?
Yeah. And the first thing to say is, in terms of statutory nuisance moving forward, it obviously will depend on the level of noise that's observed. And in updating you, I have indicated that what officers have observed is higher levels than they had observed back on the 2nd of December. But secondly, just to come directly to the question, best practical means, it's everything that the premises could reasonably be expected to do. There is that sense of it, looking at all the facts and circumstances, and those circumstances include the grant of planning permission and the history, which it's right to say are facts in the background. But that does not mean if the level changes or if the premises are not doing things to help themselves that we couldn't on another day, in principle, issue an abatement notice. But I'm not going to constrain officers seeing it as they see it moving forward.
I don't agree with you on a number of those points in relation to BPM, including the history of the planning permission, but that may well be a matter for another day, but I will correct it as I go. You have effectively, Mr. Ranatunga, just presented the review application to the committee, and that's noted. You have also presented an update which was not foreshadowed in any way. Can I just confirm that you, on behalf of Environmental Health or Ms Berry or anybody else, have not submitted to this committee the letters that you have just referred to before the committee, or any details of site visits, any measurements, or any of the other information that you have orally presented to the committee today?
So I don't accept the fact that I presented the review application. I hope it's clear, and I will reiterate this. The application itself is withdrawn. It's not pursued, but it's right that you know the background and the reasons why the Environmental Health Department withdrew its application on the 2nd of December. In explaining that to you, I have had to go into the background and what the review application was about. And then in my respectful submission, it's right that we, as an Environmental Health Department, update you as to what the position is today. And I haven't said anything other than the application is withdrawn. I'm not pursuing it. But Environmental Health, we do have concerns about noise from these premises, looking at what's happened since. It is right to say I do not have those letters in this bundle, but they are all, in fact I've read from them, letters that have been sent to the premises. And there really cannot be any objection, any proper objection to that.
There is a strong objection. I'm just clarifying that the Environmental Department did not seek to put them before this committee, and so far as these proceedings are concerned, that was an ambush. No answer, thank you. Can I clarify this? The Environmental Health Department, whether this officer or her predecessor, who, as I understand it, was her managerial superior, Mr. Brown, looked at the application for Faith in Strangers, both for the licence application and the planning permission in 2018, and together with the premises, through pre-application process and thereafter, designed the acoustic attenuation that was to be put into Faith in Strangers, designed the condition to go into the planning permission to support it, and thereafter signed it off as acceptable.
Sorry, you're supposed to be asking questions and not making representations. You'll have an opportunity to make your representation shortly.
That was a question.
I can take quick instructions and answer the question. It's right to say, I think it's Mr. Brown, who has since left the council, was involved both in the planning application and the licensing application, and did make comments on that, but not Miss Berry, who sits next to me.
Just one more question, if I may. What is it that the Environmental Health Department are before the committee asking them to do today?
I think it's right to just be as clear as I can on that, because we were clear in our letter of the 13th of January. We will be attending the hearing to assist the committee as to the reasons for not pursuing the application and to explain our position. I am not pursuing the review application, but clearly you have a hearing where you're going to hear from a number of people who want steps to be taken, but I am not asking you to take any steps because of the position that I've explained.
Thank you, Madam Chair.
Thank you. Do Mr Randall, Mr Duffy and Mr Ford have any questions for Mr Ranatunga? Do members of the committee have any questions for Mr Ranatunga? Okay, so this is the point of the meeting at which members of the public who have submitted representations will get the opportunity to present their case. I would ask that members of the public try to avoid repetition of points made by previous speakers when addressing the committee. Mr Rees-Gay, please present your case as legal representative of the residents who have submitted representations up to 25 minutes.
Chair, thank you. Obviously, in terms of the time frame, I'll desperately try and stick within that. I may wobble over, but I believe Ms Clover may ask for extra time as well, just to make you aware. So, Chair, I act for Georgina Wilson-Powell, Beth Pritchard and the Residents Association and 7 members of the Cliftonville Court, as listed and set out on page 107 of your papers. The residents occupy the flats directly above Faith and Strangers and live across all of the 4 floors within the block of flats, and I would say they are very much a community. So in my presentation, I'm going to follow cover the following 8 points: background information, the supporting evidence, the residents to address you to hear firsthand, but I'll probably do that at the end now. I'll move it so it's a little more succinct. The EHO position, which has been summarised, the response to by Faith and Strangers, a summary of the current position, public nuisance and the guidance, and then the outcome. So in terms of ease, I'll speak on the main agenda pack and then their supplementary agenda packs 1 through to 3 that you've been given. So by way of background information, if I could please turn you up to page 107 of the main bundle. All of the members of Clifton Courtville Court that you see here today and that have submitted representations, 8 in total, we say very much are a community. It has been affected by the operating of Faith and Strangers to such a degree that a clear public nuisance, we say, has been ongoing, is still ongoing, and causing them all substantial disturbance and loss of private amenity. Importantly, within those representations you'll see in the bundle, I don't represent them, but there's one on page 100, which is not from a Clifton Court resident. So this is from 1 Dolby Square, which is over the road, and this evidence relates directly to the issues from increased noise on the street late at night between 0200 and 0230 from Faith and Strangers. It should be noted, and as set out on page 108, that my clients, had EHO not launched this review, then they would have done it themselves. For clarity, and as is stated, my client have lived in the flats for over 2.5 years, which was prior to the nightclub opening, okay? And that, for clarity, is not they were there 2.5 years before the nightclub opened, they were there for 2.5 years, which happened to be before the nightclub opened. However, 5 of the residents in the Cliftonville courts who have submitted representations have lived there for many years. You'll see at page 94, an owner-occupier, that's Jackie, in flat 11 has been there for 20 years, and indeed similarly on page 98 shows that there's been an occupier there for 50 years. Importantly, it cannot be claimed that Faith and Strangers was there before the residents. Prior to the nightclub opening, it was felt by all the residents of the Cliftonville Court that it was a peaceful residential area and a lovely place to live. Some 10 months ago, now Faith and Strangers changed its business model from a private members co-working space to a nightclub. It's essential to note the operation was granted planning permission and a premises license after the authorities were told it would trade as a private members club. And again, if I could turn you up to page 118 of your pack. and it states, I'm reading from the very first line, the space will provide a place for freelancers, small businesses and entrepreneurs to rent a desk on an ad hoc basis or permanent basis and then relax in the evening with their guests. It will enhance and celebrate Margate's art and cultural scene by hosting arts, performance and dining events. Entry to the workplace and establishment will only be granted to fully registered members, signed-in guest members and temporary members ticketed. In particular, in relation to public nuisance, and that's 3 pages on page 121, it goes on to state, as the space is a members-only location with guest sign-in system, antisocial behaviour is not anticipated, nor any late-night disturbances. Any performances will take place at the furthest point from the above residence towards the Ethelbert Terraced Road. The above is again echoed in the covering letter for the licensing application found on page 122, just that's the page over. Our clients have no objection, and again this is summarised on page 128, which is the actual public notice that went up back in 2018, and that reads, Flying Colours will offer a social space for members and their guests to relax during evenings and weekends. A provision of hot food, beverage, art and live performance, screenings and academic talks will form the mainstay of our entertainment and cultural programme. So on that basis, for the planning and licensing, there was no mention of a nightclub. Yes, the hours were granted, but that was for those elements to take place for private members, not for a nightclub, is what we say. Our clients have no objection to the private members' co-working space or the style of operation that was mentioned in that application. However, things have changed at the premises, and it clearly has become a nightclub. There is no disputing that the premises does now operate as a nightclub. It is not denied in its witness statement at all in Faith and Strangers. The advertising of DJ nights can be found in the pack at page 43 to 45 of the additional document agenda pack, supplementary agenda pack 2. The premises has also been reviewed by DJ Magazine, an article titled 10 New Clubs Opening in 2021, and this is agenda pack 3, pages 20 to 22, where it states, the venue is a technological marvel, Function 1 and full fat sounds, light, and an installation that reacts to crowd activity. In the supporting emails, and again in supplementary agenda pack 2 at page 175, it does confirm that DJs come from across the country and around the world to play at Faith and Strangers. At page 58 of the supplementary agenda pack, documentation from the residents shows that Faith and Strangers linked to Kilpsch Audio, whose strapline is pissing off the neighbours since 1946. So it's that type of mindset. What has the change meant then to the residents? So most weekends and now midweek, because it started on a Wednesday, public nuisance is created as a result of the playing of music from the premises from 7 o'clock. From 9 p.m, the bass can be felt travelling through the building, and it's possible to hear song melodies and actual lyrics. The noise becomes louder and creates more disturbance as more revellers enter the premises. As a result, residents of the flats cannot relax and enjoy a normal home life. Even watching telly has become near impossible in some of the flats. It's not just the noise travelling through the building, but it's an increase in the drunken cheering, whooping, whilst dancing, and the revellers as they enter and exit, access and egress the premises. Residents have been disturbed by revellers ringing their intercoms, which are on the side, trying to access the club at all times. In addition, noise from the scraping of the furniture and the use of the electrical hand dryers in the toilets can also be heard. As a result of this, the residents of the flats are regularly complaining to the Environmental Health Department, as you have heard. EHO advised that a sound diary be kept, which it was, and which can be found at pages 115 and 116 of your main agenda pack. If I could please turn you up to that. So this came from Georgina's and Beth's flat, and I suppose obviously it's 2 pages worth, but interestingly to note that those in yellow were issues when the abatement notice was in place, and indeed those in red when this review had been launched. So this highlights that against the backdrop of what was a noise abatement notice, again we've heard that this has been withdrawn, and a review, this only being heard now, that the instances of nuisance have not reduced, they've become more frequent and more impactful to those that have made representations. Most importantly, there's been no meaningful action to mitigate the noise nuisance, and as you'll see from page 55 of the residents' additional material, faith in strangers is not currently corresponding with the residents. I believe that's because of legal instruction. This nuisance has become so significant that Georgina and Beth have slept in a camper van on weekends and indeed have looked to rent alternative and have rented alternative accommodation and have lived with Georgina's mother for a period and will remain there until this matter is resolved. In terms of the evidence of these issues from for the residents, it can be found at pages 115 and 116. If you then turn, please, to page 13, and that goes back to EHO's papers, just to highlight the salient points, so that it's not just the residents saying it. So in the review papers, it confirms complaints stated in October 2019. Importantly, it states 5 were from separate households, with Cliftonville Court as one of the Residents' Association. My clients at that time weren't the head of the Cliftonville Court Residents' Association, clearly showing, contrary to what EHO have stated, that it can't show community impact. We say that it can show community impact. EHO again at page 13 confirmed that complaints of loud music and patron noise. It confirms that specialist noise recording equipment and out-of-hours noise control services from EHO were fitted. Page 13 also clearly confirms that Georgina's and Beth's flat, there was clearly a nuisance. On 7 separate occasions, and as set out, loud music could be heard from within the complainant's flat and considered to be a nuisance. On page 14, it goes on to state, it is evident that the sound installation proposed and agreed in the original planning application has not achieved the desired outcome. Turning you up, and just so that you get a flavour of those reports, because we feel it is important. So if I turn you first up to page 36, that's the actual noise log that EHO kept. Page 38, on the 10th of July, there was an audible dance music with a sound of people noise. At 23:22 it states, I went into the second bedroom and the noise level was considerably louder. At 23:27 I could hear chanting of "It's coming home." Obviously the Euros were on then. And then it says, in my opinion, it would disturb sleep and prevent sleep, especially in the second bedroom. So it's that level. Page 41. And that's the 4th of September. The use of hand dryers in the premises were also audible. The music became louder and singing could be heard, but not at a level of where you could distinguish the words. This was from a DJ sound system. Page 42, it continues, I turned the TV up to a reasonable level and the bass was still audible over the TV. When leaving the flat, it was noted that the music was audible in the communal hallway. I feel the noise level would affect sleep. Page 43, a queue of people were waiting to enter. The DJ was playing disco-type music. A whining noise could be heard from the hand-drying machines in the toilet. Importantly, EHO at this time visited another flat that evening, and we now know that that's flat 1, and it states that the layout of this flat was slightly different. We entered the lounge where we could hear the music, a drum beat from below, however not as bad. We could not go into the baby's room as he was sleeping. It was explained he's often woken by the shouting and music from downstairs. Continuing on page 44, they put the TV on at sound level 8, which is substantial for a small flat, and the beat from downstairs could be heard. When we left, we walked to the front of the building where a queue had grown, possibly 25 waiting to enter. This is then supported specifically on page 46 with the actual readings, and I'll just highlight a few at certain times. So on Saturday the 18th, at 23:12 on the Friday the 17th, I'm Every Woman, lyrics discernible. Saturday the 18th, 1952, singing from customers at the balcony. 23:22, louder again, intrusive, bass beat around 33 decibels. 23:41, music would disturb sleep at 29 decibels, so we're already over that. 23:50, hitting levels of 38 decibels, so that's 7 decibels higher. And then 0026, Somebody Tell Me, song being can be discerned. 0052, Madonna Like a Prayer, thumping noise extremely intrusive. At points reaches 39.4 decibels. That's a good 10 decibels over. Pages 50 and 51, the noise recorder transcriptions from the 24th and 27th are very similar. Again, late hours, 0106, music level at 31 dB, bassy and intrusive. 0224, hollering and whooping from patrons. I Want Your Love, lyrics audible. 0307, furniture being moved. So not only has the night gone, they've been disturbed with that, and then there's the clear up afterwards. Page 55, on the 9th of October visit. Based on this evening, the level of music was significant intrusion on the use and enjoyment of the complainant's home. Page 58. A letter from EHO to Faith in Strangers clearly states we received a complaint from at least one resident in the area who claims they've been caused a public nuisance by your premises. Page 62, and this is a letter from Christopher Brown. Right, for information, we have now had 6 complaints from separate households. Based on a visit of myself and my colleague, we both concluded that in our opinion a statutory nuisance was being caused. Patron noise is certainly an issue and has been noted on a number of occasions. Chair, that was just to give you a feel of what these guys and some of the residents have put up with, and obviously that's not just them saying them. That is the environmental health officer going to their flat and seeing that. The point is obviously that they've made, yes, it was specific to that flat, and that's what I read out, but I also read out the snippets that they were aware of other residents being affected, and that's to my community point. So then just to turn you up specifically to what the other residents have said, correspondence that's contained in Supplementary Agenda Pack 1 confirms that Donna Walker, unfortunately she couldn't be here today, was writing to the EHO to say that they were being affected. So pages 14 to 20 is that correspondence between Donna Walker and Amanda Berry in relation to noise issues, both from loud music and loud patrons. So it's not just this flat, others are doing it. Page 26 to 27 is a text message from Jackie. So that's Jackie sat here on the top floor, flat 11. She confirmed that on Saturday, the 4th of December 2021, so that's after the 2nd of December when it's been withdrawn, she said they've really turned it up, almost like a celebratory salvo. And again, that's in your pack. Page 29 confirms that complaints continued to be reported to EHO and that music was now being played on a Wednesday. So meaning now that 3 out of the 7, so that's Wednesday, Friday, Saturday, are now being ruined. And again, an email on the 16th of December, this can be found at page 36. These concerns about Wednesdays are also confirmed by Donna, so it's not just these guys confirming it. Donna Walker's also confirmed it, and the high volume, and it's much higher volume than it used to be. And we would say, obviously, that was due to the perceived lack of action that was being taken. Another resident, Rosie, who's out with her children on the 3rd floor, page 49, on the 29th of January, stated, "It's never been this loud. My floor is vibrating." And again, all of that is in the papers there. I was going to get the residents to speak now, but I'll wait just for consistency to get them to speak individually later. So in terms of the EHO position, obviously you've heard they have withdrawn it. The point that we would like to make in terms of the residents, and Beth has already tried to say it, that there's only an EHO call-out service that only operates between June and November, and only on a Friday and Saturday night, and only until midnight. Obviously, we're dealing with a nightclub that operates through till 3 a.m. on a Friday and Saturday, and that's in December, and as you're now aware, January from the representations, and it's, you know, to get that evidence that's needed in terms of formally, it can't be done, and therefore the residents are hamstrung currently at the moment. We therefore say, obviously, on the evidence that I've just given you, that there is and continues to be a public nuisance. So, from my client's perspective, and indeed from the flat residents, they were and are bitterly disappointed that the EHO did withdraw their representation. From their point of view, as residents and a resident association, when they went with their issue, they hoped as a local authority body that they would obviously get the evidence that they required to deal with these issues. You know, if it meant that they had to speak to another neighbour who'd already complained, then that should have been done. And, you know, to have the rug pulled from underneath us back in December was heartbreaking, obviously living with this and then obviously it getting worse. So at no stage prior to the review being withdrawn did EHO allude to the fact that there would be issues with only taking reading from my client's flats. Other residents would have allowed recordings to take place if this is what the council believed is required. And we understand that they are now doing that, which is brilliant. We're not of the same view. We believe that there was a public nuisance at that time anyway, and that the review should have been left in. As you have heard, residents are still making complaints, and now, fortunately, EHO are on board with that across the flats and not just solely within flat 3. So the response then we received 290 pages of documentation on Tuesday from Faith in Strangers, and I'd just like to deal with a number of points before dealing with the main issues of that. In relation to the letters of support, we believe that the council is quite correct and that they're not representations, as they clearly don't address any of the licensing objectives. They are purely letters of support. Paragraph 18 of the witness statement on page 9, and that's in your supplementary agenda pack 2, states that they have letters of support from the local councillors, and I would urge the committee to read these carefully, and indeed if I could turn you up to those. So it starts at page 29, and this one's from Alan Curry. It states that they have letter of support. Sorry. It states Councillor Curry asked that every avenue be explored to prevent the venue from losing its music licence. The premises wouldn't survive without it. That he was being informed that the soundproofing has been installed to the specification required, which has meant a particular business plan has been followed. It also states that he believes that the owners are willing to make improvements to reduce any noise issues affecting residents who live in the block above. I'm not sure that last sentence has rung true. In terms of page 30 and Mr. Yates, his email was deemed support. If you read it in detail, it just confirms that, and he states, information provided about F1 sound and F1 acoustics is information he has been told to be true, although he hasn't seen the evidence with his own eyes. He also states he is a member of the workplace, so there'd be a conflict of interest there anyway. In terms of Councillor Keane on page 31, it confirms the business have told them that they've complied with the soundproofing condition, but a late licence is a necessity for the business. Some of the residents have written to these very same councillors, and as can be seen on page 15 of our supplementary agenda, pack 3, it's been confirmed that Councillor Curry was sorry to hear that the issues were ongoing, but he unfortunately had no jurisdiction on how Faith in Strangers ran their business. On page 11 then, and moving on back to their statement, it states, in our planning and licensing application, reference has been made to music being played most frequently on Friday and Saturday nights. Thus 34 out of 24 weeks is not out of step with the original application. What we would say about this is what is out of step is that the planning and licensing application didn't state that it was for a nightclub it stated it was for a private members club only. Pages 13 and 15 discuss the sound system specifics. It states that it's a domestic hi-fi system and that it's akin to a large domestic stereo system. This is in contrast to the DJ magazine article that I've already referred you to, that states there is a Functon 1 and full-fat audio sound system. I'm not a speaker expert, and maybe Miss Berry might be able to comment, but it being reported in DJ magazine, I presume that it's not just a domestic hi-fi system. In summary, I suppose it's quite telling, out of the 290 pages that there are in their paperwork, 25 pages touch on noise, the basis of this actual review. So in particular at page 18, in terms of best practical means, and that's already been discussed, it states, paragraph 41 sets out elements of work that were undertaken to meet planning conditions. It is referenced on a number of times within their supporting paperwork, including their revised operating schedule, page 214, and indeed in their sound management plan of August 2021 on page 223. And just turning up to that on page 223, just to give you context, certainly for Beth and Georgina, the area obviously highlighted in blue is where they do have sound attenuation works. However, the other area around it, all of this area, has no sound attenuation at all. So it's literally just specific, whereas sound is bouncing around all of these other areas, and that's all the planning condition focused on. I still do have a fair bit to go, Chair, but as discussed, Ms Clover's also got a long time as well. So, following on from that, Chair, Faith in Strangers, it seems, are of the opinion if they can meet their planning conditions, that somehow it's then okay to create a public nuisance. As we're aware from page 14, it clearly states from Environmental Health, it is evident that the sound insulation proposed and agreed in the original planning application has not achieved the desired outcome. In our view, there are clearly structural issues with sound transfer through the building from Faith in Strangers that clearly have not been addressed. Most notable in the Faith in Strangers had a noise assessment carried out in October 2021 and indeed by a professional, but this hasn't been seen and none of the findings from it have ever been circulated. There's no correspondence in the Faith in Strangers documentation to show how they're working with EH and importantly their neighbours to deal with these noise concerns, and I think that's been reiterated by what you've heard this morning. Instead, there are 178 pages of support letters. These, having read them, state what a perfect workplace it is and a very high level office environment. Some do touch on supporting DJ-led nights. The issue that we say on this is that it doesn't deal with the matter in hand, the noise, and it doesn't mention the licensing objectives. Cynically, one might say that they'd lobbied all the people that use their own offices. The remainder of the documentation relates to the benefits of live music to the economy and the importance of that live music is being overlooked. No one would disagree with that, and that's why there is. No one would disagree with the importance of live music, and that's why there is the Live Music Act, and it allows live and recorded music to take place between the hours of 0823 for up to 500 people, if the premise has a license. However, should you wish to carry out live or recorded music after that, you need to apply for your authorization. That is the crux of why we're here today. That you should you choose to operate outside of those hours, you need to do so without creating a public nuisance and indeed be accountable for that operation. Paragraph 46 of the Faith in Strangers witness statement is particularly telling and indeed explains why the focus of the documentation is not focused on how issues can be resolved, but is the main reason why they should be allowed to keep their later hours. It states, and if I could turn you to it, it's page 20 in Supplementary Agenda Pack 2. It's patently clear that for the organisation to be economically viable, busy Friday and Saturday nights with music and dancing are what generate revenue. The money generated by the creative workspace is an ancillary to the main source of income, while sadly people do not tend to spend money when attending spoken word poetry nor academic talks. these are loss leaders for the business. This statement also clearly explains the focus of why the documentation relates to the live music. It could not be clearer that the operators of Faith in Strangers have decided that income generation outweighs the needs of the local residents in the flats above, and this is the reason why they continue to play loud music until late into the night, causing hardship and distress to the flats. Indeed, this rings true with what I've already said. Councillor Curry's email saying preventing the venue from being allowed to play music from 11 p.m. would mean that the venue would not survive financially or in its present form. And indeed, Councillor Keane reiterated the same, stating a late licence is a necessity for the business. It's telling that there's no denial that noise concerns exist for the residents, just that because they have met the planning condition for a co-working space, that they can operate as they wish. Much has been made of Frank's as well in terms of history, but just to bear in mind that shut in the early 2000s, so almost some 20 years ago, so in terms of timeframes, just so that you're aware. So in terms of a position, from the evidence that you've heard orally and indeed in writing, it's clear that the issues continue. There is public and statutory nuisance taking place as a result of their operating style. Complaints have been ongoing for 2 years and still matters have not been resolved, and there have been no attempts by the premises licence holder to meet with residents to explain future operations and how indeed they will deal with the issues. Rather than attempt to mitigate the problems, the opposite has been the case, seeking to operate on Wednesdays as well as weekends in order to adhere to their business plan. As well as the issues from noise from music, there are issues from noise from revellers, entering and exiting, the queuing, furniture, and indeed the hand dryers. So where does that leave us in terms of public nuisance, the guidance and the statement of licensing policy? This is all covered specifically on page 110 of your big public agenda pack, but just to read the salient points, and I'll start with paragraph 11.1. The proceedings set out in 2003 Act for reviewing premises licence represent a key protection for the community where problems associated with the licensing objective occur after the grant of the variation of the premises licence, and that's exactly where we are today. 215, through representations, the licensing authority can consider what constitutes a public nuisance and what is appropriate to prevent it. It's important licensing authorities focus on the effect of licensable activities at the specific premises on persons living and working in the area, which may be disproportionate and unreasonable. These issues mainly concern noise, nuisance, light, etc. 216 again is very important, and I'll read that verbatim. Public nuisance is given a statutory meaning in many pieces of legislation. It is, however, not narrowly defined in the 2003 Act and retains its broad common law meaning. It may include, in appropriate circumstances, the reduction of living and working amenity and the environment of persons living and working in the area licensed premises. Public nuisance may also arise as a result of adverse effects of artificial light, dust, odour, insects, or other prejudicial to health. Then at 2019, again, is extremely pertinent, where applications have given rise to representations, any appropriate conditions should normally focus on the most sensitive periods. For example, the most sensitive for people being disturbed unreasonably loud music is at night and into the early morning, when residents in adjacent properties may be attempting to go to sleep or are sleeping. This is why there is still a need for license of performance of live music between 11 p.m. and 8 a.m. In certain circumstances, conditions relating to noise emanating from the premises may also be appropriate to address any disturbance anticipated as customers enter and leave. This is then also reiterated, and again, obviously due to time, it's set out very clearly on page 110 and onwards, but it's also reiterated in your very own statement of licensing policy. Just to touch on, the committee will also no doubt be aware of the, no, I won't mention that one, that's fine. So in terms of where the residents are, as it were, they don't want to be overzealous at all. They're not seeking revocation, although we think the way that Faith in Strangers have behaved, decided not to work with us, you know, the position that's been taken at this very review, we should all be working together to make sure that this is dealt with. Instead, we've just got an entrenched view that it's not us. They've got to go because we fulfilled our planning conditions. Our view for the residents would be we would like to seek that all licensable activities finish at 2,300 hours daily This will eliminate the noise created by loud music, as well as the noise from the revellers. So that's all licensable activities at 2300. The electronic hand dryers be replaced with towel dryers to deal with the noise from the dryers, or an alternative be sourced that aren't noisy. Indeed, that all furniture have rubber socks. As Mr. Ranatunga mentioned, that there be the removal of the Live Music Act exemption, obviously because this is a review which deregulates live and recorded music before 2300, and that a noise limiter be fitted and conditioned to the levels that are deemed appropriate by environmental health themselves. We've also, I believe, set those levels. So, Chair, those are my submissions on behalf of my clients and indeed the residents. And the residents would now like to brief you just so that you get a personal view of where they are. So I don't know if you've seen the image. Faith and Strangers on the second floor, and these guys are all flats above it, over 4 floors. So I suppose if we start with... Oh, could we start with... Chair, do you think we could start with Rosie May, who's waiting with her children? Is that all right? Please. Is she here? Or does one of you want to go while someone gets her? Beth, do you want to go?
Mr. McKinley, was he? No, yeah, George.
Would you like to go now? I can do this. Unless she's just coming in now. Oh, here she goes.
Madam Chair, I don't know if there's any point in me raising the fact that it was supposed to be 25 minutes each, and it can only be people who've made a representation in advance who can be allowed to speak.
Sorry, this is only 5 minutes.
Yeah.
Each.
Come on, Rosie. You're in, please. Yes, please.
So this is for residents who have submitted representations to address the committee, and it's up to 5 minutes each.
Oh, do I just... Okay. Okay.
I'm sorry, this person hasn't made a representation.
No, Rosie May.
Oh, sorry.
Rosie May's from the flat.
Yeah. The representations at post 92. Say again, sorry?
All the flat numbers have been excised from my bundle.
Sorry, this is page 92, Rosie May. Thanks, Rosie.
Hi.
Hi, Rosie May.
Yes.
Would you like to...
I don't know what I'm doing. I need to, like, be told.
Sorry, Rosie, you just
Sorry.
need to tell them
Your experience of what it's been like.
of the noise.
Okay.
I don't want to put words in your mouth.
Yeah, no, that's fine. Well, obviously it's been hard. I have a little boy that has autism. He's 3 years old. He, at the moment, goes to nursery, so he's sleeping and... sorry, I'm very nervous. I'm not very a confident person. Yeah, he has autism. Obviously, if you look up the words autism, you understand that it's very sensitive to hearing and noise and feeling stuff and like other things like foods, other stuff like that, but it's mainly on hearing. In his bedroom's directly up above Faith and Strangers, so when the music's thumping through the building, you can actually feel it on the floor. It's mainly in the boys' room than it is through the whole of my flat, which is more concerning because obviously it's the boys' room. I also have a 1-year-old as well that sleeps in the bedroom with Freddie. I obviously struggle with mental health, which doesn't help as well. So yeah, I don't know what else to say. Sorry.
No, that's lovely.
Sorry. Yeah.
That's fine. Thank you, Rosie. Thank you. Would other residents like to basically put a representation?
So, if I may, the evidence that that Faith and Strangers have put forward has got some personal suggestions about my integrity. I would like to be able to address them after they've been made, rather than talk about them now, if that's okay. Would that be possible?
No, it's not possible.
Okay, so let me read this to you then. My name's Beth. I live directly above Faith and Strangers, sharing a floor with their ceiling. My father taught me you should play the ball, not the man. It saddens me greatly, having read the submission that Faith and Strangers have decided to make, that they've opted not to work by that maxim, and that I'm now in the position where I feel it necessary to talk about my personal history in a licensing committee which is here to talk about public nuisance. By way of background, I am an accountant, a charity trustee, chair of Cliftonville Courts Residents Association, and prior to the pandemic, I was vice chair of Keyworth's Primary Schools Board of Governors. I will be glad to answer any questions the committee has about the personal matters raised by the licensees. Suffice to say, I do not recognise many of the points they make about me. Whilst I do not see them as relevant to a licence review hearing about ongoing noise nuisance, given the picture that has been painted of me, I would be most grateful if the committee would allow me to clarify the following. Prior to the purchase of our flat, the licensees of Faith and Strangers, please, this is going to seem very out of context unless you've read their submission, so I really do apologise that this seems incredibly irrelevant. However, it's been raised in their evidence, so I just want to address it. Yeah. Prior to the purchase of our flat, the licensees of Faith and Strangers also wanted to purchase it. However, they could not agree on a purchase price with the vendors. Having seen the evidence submitted to the committee by the licensees, I do wonder if this is a source of resentment to them. That aside, we purchased our flat for £144,000, not £120,000, as the licensees have suggested. The flat was in very poor repair when we moved in, and we spent considerable sums refurbishing it, windows, bathrooms, etc. In total, we have spent upwards of £175,000. Against this backdrop, the offer the licensees and freeholder put to us to buy our flat for £150,000 was far from generous. The licensees also omitted to mention that when they wrote to us about the offer, they intimated we could be open to legal action if we raised further complaints with environmental health. With reference to my living arrangements, I work at home in Cliftonville Court. My life is in Margate, I am registered for the doctors in Margate and pay council tax here, and recently applied to be a local school governor. I can confirm, as the pack says, that I own a flat in London. I'm not sure why that is relevant, but I can also tell you that there is a lodger living in there. I would like to apologise to the committee for bringing such personal matters to you. I'm going to leave it there. I'm chair of the Residents Association, so I'm more than happy to answer any questions generally about the building, but I think that there are enough residents here to bring to life the experiences that we've had.
Thank you. Would other residents like to speak?
Yes, please. My name is Georgina. I also live in flat 3, Cliftonville Court, immediately above Faith and Strangers. I run my own business. It employs 3 people locally, and I'm the environmental editor at the Margate Mercury. I bought the flat, as Beth said, we moved in June 2019. It's my first and only property. Since May last year, I've been kept awake nearly every Friday and Saturday night, often till 3 a.m. or later. By Wednesdays each week, I dread the weekends coming. I often get home late on a Friday, only to be met with bass and patron noise, so I walk in the door at about 9 o'clock. We've registered up to 50 decibels in our flat. It's impossible to do anything normal. At gone 2 a.m, I can hear lyrics from songs and people singing and shouting for the DJ to play longer. Then we hear the clean-up, which we've talked about, which you can also hear. So sometimes it's gone 3 o'clock before we can sleep 3 o'clock in the morning before sleep is possible. The venue's cleaning staff often wakes us up before 8 a.m. on the weekend, so the scraping furniture around the floor is like fingers down a blackboard. It's so loud. And then it happens all again the next night on Saturday night, so I spend all day Saturday dreading the repeat, and we're already tired from the lost sleep. Some weekends we only get 7 or 8 hours sleep over the whole weekend. This is what nearly every weekend has been like for us, month after month after month since May, and it's had a hugely negative impact on our mental, emotional and physical health. We're stressed, anxious and worried all the time. We've got no quality of life in our flat between Thursday and Sunday. We can't watch TV, we can't have dinner together, we can't invite people over, we can't have family to stay. It's the same throughout every room in our flat, and simply put, the soundproofing does not work. We've had to call out environmental health every weekend, as you've heard, when their call-out service was available, stopping our normal life in order to gather evidence for a noise disturbance that residents of this block are the victims of, while the venue have been allowed to continue operating in full knowledge of the damage they're causing to the block. Some weekends we've had to resort leaving our home in the middle of the night because we can't stand the noise anymore, sleeping in a camper van even in winter. Because the noise levels have increased after the licence hearing was issued, I found it all too much in December and I had to leave my home entirely and stay with family for most of December. The original licence hearing in December being cancelled directly cost us a huge amount, as we had to go and rent another flat on top of our mortgage, unable to yet face more weeks of the noise and uncertainty and feeling under threat from the unrepentant attitude that we've been facing. It's had a wider impact as well. It's in the packs as well, but we've had to twice delay our IVF treatment because the noise disturbance caused by the events has meant we've been unable to proceed, knowing that we can't sleep or relax at a time when both are crucial to success. And we've also had to divert all of our savings into these legal fees. And it's not just us. Our neighbours' kids are being kept awake, retired people who aren't well are being kept awake, and neighbours have left and now avoid the building directly because of the venue. I can't understand how we can talk about community-minded business while the 12 families of Cliftonville Court are being driven out of the community that's been theirs for decades. Since the licence review in December, the venue's got even louder, but we've been unable mostly to call out environmental health to witness it because the call-out service isn't available. Without a robust environmental health service, the need for this licence review is even greater. Faith and Strangers choose to be a nightclub, and they choose to have DJs and live music until 3 a.m. The residents here haven't got a choice in this, and yet we're bearing all of the emotional and mental and financial costs. Thank you.
Thank you. Craig McKinley.
Thank you very much, Madam Chairman. I'm here on behalf of Charlene Bryant, and as you can imagine, this is quite unusual for an MP to be at one of these events. But this case went over a boundary where I felt that I really had to be involved for so many residents. Now, just going back, if I can run through some of the notes and refer you to some different pages. I'll refer to the public document pack, which is obviously the only one I have. On page 12, when this application was first granted in 2018, the application by the applicants was for a change of use of the first floor from nightclub to a mixed office and restaurant and arts venue. Right, so that's quite clear what they intended. But they were obviously granted in August 18 a licence to permit live and recorded music Sunday to Thursday till 1 a.m. close, and Friday and Saturday and bank holiday Sundays 3 a.m. close. So they're technically obviously operating within the licence that they were given, but it would seem to me their primary objective, which litters through a lot of these documents, was for it to be this sort of members club with poetry and that type of thing. I'm just referring to their own document, page 118 of the public document. It says the space will provide a place for freelancers, small businesses and entrepreneurs to rent a desk and then relax in the evenings with their guests. It will enhance and celebrate Margate's arts and culture scene. Now, those type of statements at the start of when they first wanted this place were quite clear. Now, I realise that when licences are granted, and drinks licences particularly with times in mind, they're often given by good faith by officers with the assent of committees and with a hope that that is what it shall be. But I'm afraid things sometimes evolve, and I think that is why we're here today. Now, I have some disappointment to aim at some of the officers of TDC, because I think the residents feel that they haven't really been on their side all the time. They had much hope when that abatement notice was issued. They had much hope when there was that planning here, or the licensing hearing due on the 9th of December that was then withdrawn. But, you know, I thank you today for what you have been able to put into the arena, and I really do. So it's really been left to residents to try and bring this, to explain with some clarity to the committee. I've had reports, I think they're probably with you, from a number of residents showing, you know, just how dreadful life is. That's from Donna Walker from flat 9, from Jacqueline Davies, who's here at flat 11, and of course Georgina Wilson-Powell and her partner in flat 3, and from Rosie May Deal. Now, people think MPs have power. We don't have any power. I'm a backbench MP. I might have influence, but I have zero power. You are the first tier tribunal today of a licensing potential escalation, because it could go from here to the Magistrates' Court. You have real power today, real power, because what you are deciding today will mean whether people can live a decent life, just enjoying what they have and what they've bought, maybe the primary asset they have in life. They live there just wanting to look over the sea and enjoy life as we all do in our properties. And what is happening, probably at the outcome of this hearing, could actually decide whether the asset that they love and have enjoyed will be worth what they paid for it or next to nothing. It seems to me, and I had high hopes, I really had high hopes for Faith in Strangers based on those statements that they gave, that it would be what it said it would be. Now, as part of when they were having to go through the sound issues, there was a mention in here that their sound system could be 100 decibels, but they didn't think it would ever be used at that level. Now, I know 100 decibels, 10 decibels, what does that mean? Can I just give the committee some idea what 100 decibels means? 100 decibels is a jet taking off at 300 metres. 81 decibels, which I think all have appreciated might be reasonable sound volume, each 10 decibels is a tenfold difference. So 80 to 90, that's 10 times the music intensity, and our ears record that as twice the volume. So 80 to 100 is 100 times the sound intensity and 4 times the real volume on our ears. Now, we've had a lot of noise recording, and that starts from page 45 onwards. And it's been pretty grim reading, frankly. No, sorry, we had a number of noise recordings, I think from page there's so many here, 108 onwards. Yeah, the various noise recordings have taken place at strange times of day, and it seems to me, after 11 o'clock, the noise has gone up. Not down, it's actually gone up at exactly the time when people like Rosie May Deal's children are trying to go to sleep, when other people are trying to get a night's rest so they can go to work the next day. That is when the noise has actually gone up. I'm just getting started, but no, I'm trying to just amplify some of what Mr. Rees-Gay has said. But as I say, I wouldn't be here unless I was concerned. I mean, what are we now? 2 hours of an MP's time to look after 12 residents when I've got 100,000 people to look after in this constituency. That is the reason I'm here, because I take this very, very seriously. Now, can I just leave you with one last thing about the intents of this place? I looked at their website just this afternoon before coming. They've got an event on Saturday the 19th of February that's advertised on their website. And they've got a guy coming called James Thompson. And just reading about this event. I mean, this is after they've had a noise abatement notice.
Chair, are you going to allow this to continue?
They have notice about this meeting today. It's on your website, so I don't think it's private. Can I just read?
It's a timing issue.
Can I just read their advertising? I'm here as a resident, not as an official legal advisor. Can I just say, as my closing statement, about James Jim Jimmy, the artist formerly known as Jimbo, whatever you know him by, if you know, you know. This guy has been setting trends, I think it's meant to say, has set trends and making tastes from before you were born. Join him on Saturday, this Saturday, as we collectively get our boogie on and tear the roof off. I think that's what this place intends to continue. Thank you, Madam Chairman.
Thank you. Are there any other residents that would like to talk?
Madam Chair, again, I'm really, really sorry. Could we have a comfort break, please? We've been going for quite a long time.
I was going to have one at 4 o'clock, which is in 10 minutes.
I think some people can't wait that long.
Okay, is everyone happy for us to have a comfort break now?
That's fine, we've only got 3 to go, I don't know.
Now, please. Thank you.
We'll have a 10-minute break. Welcome back, everybody. So, are we going to continue now with the residents' representation? Thank you.
As before, good afternoon. I'm Jackie Davis, flat 11 owner-occupier. I'm in my 80s, which is a consideration. You want your sleep when you get older. The noise, it's not every night and all the time, but when it does come through, it permeates through the building, through the vents, etc. You know, it's really, really bad. I've got an ongoing neurological disorder. It's called Guillain-Barré, in case you're interested, but I'm in recovery from it, but it's still evident. And it's not conducive with the noise, because, you know, I want peace and quiet with these things. Also, I'm on the reading roster for the local mass where I go to, and I'm letting them down a lot because you just can't get your sleep, and I need my sleep. We're a lovely community, made a lot of friends one way and the other. It is the noise factor. I'm all for entrepreneurialism and things like that, but this is beyond the pale. It really is. There we are. That's all I'd like to say. Thank you very much. Thank you.
I'm reading this on behalf of Donna Walker, flat 8, Cliftonville Court. My husband and I and our 4-year-old daughter live in Cliftonville Court, 3 stories above Faith in Strangers. Rather than focus on the impact on our lives, which is very similar to the others living here, who you have heard or will hear speak today, there are 2 key issues which I would like to draw your attention to. One in relation to soundproofing and the historic use of the building, and the other is in relation to noise levels. Faith in Strangers inhabits part of the Old Franks nightclub, which closed in the early 2000s. 4 of the 12 flats within our building have been in the same ownership for more than 20 years. And so we know that the levels of noise we are all experiencing today are far greater than the levels of noise historically generated by Franks. This is because the soundproofing measures which Frank's nightclub had installed were all removed. My husband and I, who are both architects, walked around Frank's in 2016, and we have photographs from that day. At that time, the space was derelict, and parts of the ceiling had collapsed due to water damage, and so we could see the historic fabric of the building laid bare. Firstly, Frank's nightclub had no windows at all. They chose to block up all of the original window openings and enclose the roof terrace with dense blockwork. Nightclubs do not generally have windows, as glass cannot stop the passage of sound in the same way that a solid wall can. By contrast, Faith in Strangers' interior is light and bright with large windows and sea views. Their speakers are located within the largest of these windows, directly underneath the front facade of our flat. Furthermore, the ceilings and walls within Faith in Strangers have also been stripped of their historic soundproofing measures. Frank's had a suspended ceiling throughout, dropped by around ½ a metre from the floor slab above, with substantial amounts of sound insulation and dense plasterboarding. Similarly, the walls and columns were boarded out with sound insulation all around, meaning sound could not travel and vibrate up through the structure of the building. Today, this concrete structure is fully exposed, giving the interior its aesthetic character, with concrete columns and 4 slabs clearly visible throughout. I also want to touch briefly on noise levels. The World Health Organization states that sleep disturbance occurs at noise levels above 30 decibels. The noise within our flat, which is 3 stories up from the venue, regularly reads well above this when measured on a noise app, and this has a detrimental impact on our ability to sleep. Faith in Strangers did propose some soundproofing as part of their planning conditions sign-off, which can be seen in Annex 1. The drawing here states that the soundproofing to their ceiling will reduce the noise by 120 to 140 decibels. This was clearly has not worked as intended. If sound was successfully reduced by this amount, then the flats above would hear no noise at all. As an architect who knows the basics of soundproofing, this is no surprise to me, as soundproofing, just a part of a ceiling alone, will never block the transfer of noise. For effective soundproofing, you have to create a sealed box within a box, where all of the internal linings are physically separated from the external structure of the building. There have been no offers made by Faith and Strangers to try and improve the soundproofing of their premises. Furthermore, it should also be noted that despite Environmental Health setting what they deemed to be acceptable levels for music some time ago, these levels have been consistently ignored, and in recent months the volume of music has got louder than it ever has been before. I believe Faith and Strangers have two choices. One is to revert to their original business plan as outlined in their planning submission of being a co-working space by day, with quieter arts and cultural events in the evenings, something which all of the residents here would support. The other is to install extensive soundproofing, which would include blocking up their windows and removing their sea views, which would then enable them to be a late-night music venue. As it currently stands, their nightclub usage at weekends is incompatible with the space that they occupy, and also incompatible with a residential block of flats directly above. Just to say, I'm on the top floor in flat 10, and I think this is devastating, you know, our community is all I can say. It's really, really upsetting. And I'm sorry for Faith and Strangers as well. It feels a really sad situation.
Residents that would like to talk?
I think. Oh, hi, my name's Trilby Ryan. I live in number 4, which Cliftonville Court, which is on the 3rd floor of the building. I've lived in my flat 10 years, and I'm a cook, one of the cooks at North Downs School, primary school. I've been in my job for 12 years. The music coming from Faith in Strangers, I first noticed because I could hear a bass line going on. And when I went out and went downstairs to investigate, and there's a doorway down the bottom of the building which leads to the club, and that's where the music was coming from. So then I went back upstairs again. I heard lyrics on at least one occasion, which was Lou Rawls, "You're Gonna Miss My Lovin'," so you can actually hear word for word, and I did think at the time that was pretty loud. But the thing that concerns me, our building's quite fragile. We're having restoration work done at the moment. It was vibrating. It vibrates. There is a thing about people outside of the club. I don't know how much this is the responsibility of the club themselves, but they did promise in their first, that our solicitor read, that they were guaranteed that people wouldn't make any noise afterwards. They were going to leave the car park very quietly, etc. On a number of occasions, because the entrance is sort of on the corner, my bedroom was above here, and I've been woken up and had to look out and see what's going on. There've often been altercations, there's bad language, smoking, all sorts of things going on, and this coincides with times when there's been late night do's at the club. So, yeah, it is a worry too. Damage to property. Our property's been damaged in the past, particularly the front door. It may or may not have anything to do with it, but we have to pay for those damages. The only other thing I wanted to say was we've just, all the residents each, I'm just sorting mine, but we have paid the best part of £23,000 each flat to pay for the restoration of the building, and it's been a very stressful thing all along. This has been going on for some time now. The building work now is going on, but we've had enough, and we would like to now, you know, we want to enjoy our homes. It grates a bit when you've paid all that money and then you have this disturbance from the club. As has been said, all of us were very happy when it was advertised as an arts centre. We were looking forward to going there. The lease too, I would like to say just lastly, the first thing in our lease, the first bit of our lease says that we are entitled to some kind of semblance of quality of life, and so far with everything, but especially with the club noise, we don't have that. So that's all I'd like to say. Thank you.
Thank you.
Oh, sorry, Mark.
All residents, thank you very much. Does the licensing team have any questions for those representing the residents? No? Okay. Does the environmental health team have any questions? No? Ms. Clover, do you have any questions for those representing the residents?
Ma'am, it's not my practice to ask questions in these circumstances. Can I take it or submit it globally to the committee that the submissions that have been made by the residents are all in contention, they're not agreed. But if I were to ask questions about each and every one of them, we would be here for potentially a long time. So I'm going to leave it like that. We disagree with the things that have been said, and I'm going to make submissions about that. But I won't be asking specific questions, but that is not to say that what's been said is conceded.
Thank you. Does Mr. Randall, Mr. Duffy or Mr. Ford have any questions for those representing the residents? No? Do members of the committee have any questions for those representing the residents? No questions, okay. I did just want to clarify actually one point with the residents, because there's a lot said about Frank's nightclub, and obviously Frank's has gone, but there's a lot been said about the soundproofing being removed from Frank's, and I heard the thing about the box in the box. I mean, is there any verifiable evidence basically to show that Frank's was actually a quieter venue for the residents than Faith and Strangers is?
Sorry, Chair, we have submitted photos and I'll try and turn those up, but obviously the elder members of the community may be able to assist.
Yes, I'd like to just add that I was a resident there prior to Frank's when it was the Starlight Club, and the noise over the years, not over the years, this is worse than it's ever been all over the years. So that's all I'd like to say with respect to everybody.
So I'm not a soundproof engineer, or I don't understand soundproofing, but has there been anything done to sort of show why the soundproofing was better then with Frank's than it is now?
There was a huge sort of a whole floor above Frank's, as far as I can see it, but the club is now in there, so that was the soundproofing, I think. Donna and Sam, who Jill read the statement from, they're architects, so they know all about the building, but the club is now in where the soundproofing was, I suppose, and it was all brick, because I remember well when they drilled out every window. The noise was horrendous, but as I said, I'm not a technical person, I don't know, but Donna and Sam could explain it, but that seems to me that's, so you're now absolutely next door to the floor where the flat is, you're just below somebody's floor. And Chris Brown, funnily enough, said to me that you must have a certain amount of metres between, even when there's public works going on, you must have a certain amount of distance between people because of decibel damage to your ears.
So previously, when Frank's was a club, there was a floor above.
Yeah.
And you now have got residential units on the floor above.
Not quite.
The club is within this. No, I don't. Because I'm
not quite.
But the club is sort of where the gap used to be, isn't it? Really.
Yeah, not quite.
That gap was the centre.
Yeah.
Yeah, that's what I thought. It was just an empty.
Yeah.
Thing, wasn't it? Rose said she never had any problems from Frank's in the past. I never heard much.
Yeah, I think you've just got to think of sound as the same as water, and it's got to be encapsulated for it not to vibrate. And I think Sam and Donna have got pictures to show the difference, and the difference that it was. And
it does.
And the design, I think the design that it is went with the original business plan, to maximise the windows, the sea views, lovely office space. That all made sense, but it does not make any sense for a nightclub. And I would not say I love dancing, I love music, but it's just not fit for purpose as a nightclub. It fitted the original plan, and it's the opposite for what it, for a nightclub.
And can I also clarify, is it just one apartment on the first floor?
There's three.
Does the sound get worse less as you go up?
I'm in the best position, but I can still hear because I'm right at the top and the far back, but I can still hear the bass. And if I had a Shazam, I could get some of the music, the Shazam out the television. So, it's because the pillars, there's concrete pillars connecting the whole of the building. That's one of the main problems as well. Yeah.
Councillor Bainbridge, may I just so there are 3 flats directly above Faith and Strangers. Mr McKinley is representing one of them, where the work most affected. The middle flat is actually vacant. hence why that lady isn't here. She would be very badly affected. Her dog used to howl when they had events in 2019. She died, unfortunately. Not unfortunately. She died, unfortunately, just full stop. But so the reason that you haven't necessarily heard from that individual is because it's vacant flat. There's another flat that would be very badly affected, flat 6. That's also vacant. So yeah, that's a bit of context. Also, Frank's was well over a decade ago, 15 years ago or so. So a lot of people have moved in and out in that time.
Yeah, well,
Alison.
From what we understand, when you had Frank's, the first lot of flats, basically, they were there, but his staff lived in there. So they weren't actually lived in by residents.
Okay, thank you.
May I add that I bought the flat, well, my husband and I bought the flat while the nightclub was there because we had friends who lived there and they recommended it and the flat went vacant and we took it. But there was no disturbance as such. A little bit of it in the summers, windows open, our windows, but not like it is today, definitely not. So it's a lot worse now.
Okay. So, any other questions from the committee? No. Okay, Ms. Clover, could you please present your case as legal representative of Faith and Strangers?
Yes, ma'am, thank you. Well, as you might imagine, there are two sides to every story, and this one is quite some story. Just with the greatest of respect to them, just to pick up on what the residents have just said about technical acoustic details and sound being like water or decibels or a box within a box or any of those sorts of things, may I put the committee on alert that all of that is wrong. Acoustics is a very highly technical scientific speciality. An architect is not an acoustician, and the information that you've been given about the difference between Faith in Strangers and Frank's is empirically incorrect. You do have some acoustic information in your paperwork. I will be touching on it briefly. Clearly, I don't get a huge amount of time, but these matters are extremely important, and you will be hearing about how the Environmental Health Department of this council, and I averted to it earlier, not only signed off, but effectively designed the appropriate acoustic attenuation for Faith in Strangers as it was going to be, as it currently is, which takes me really to my opening point, which is it's not a nightclub. Never has been. It hasn't changed the business model from what was submitted in the course of licensing application or planning permission application. And you may note from all the submissions you've heard from Environmental Health or Licensing that they do not contend any differently. This is not a Trojan horse change of business model scrabbling around at the last minute to find a way of making money. This is absolutely bang on point what Faith in Strangers is and was always going to do, and what was submitted in the course of the licensing application, the operating schedule, the design and access statement for the planning permission. Faith in Strangers conducted pre-application discussions with planning, who you will note are not here, and planning are a responsible authority in licensing terms and could be here if they had any concerns that Faith in Strangers was exceeding its planning permission or going in any way off-piste with it. Faith in Strangers engaged with all of those officers to discuss their proposals and what they were going to do, and the speaker specification and the sound attenuation possibilities before they took the lease. The freeholder for the premises had been looking for a tenant since 2016, and Faith in Strangers, before they decided to take up the building, engaged with the council and the officers to make sure that what they proposed to do was going to be suitable and effective, and it hasn't changed from the licence application or the planning permission application, and that is clear to see from the wording of both. And these are both recent authorisations. We're not talking about grants that were given many, many years ago. We're talking about in the last couple of years. In the case of the licence, we're talking about, in case of both of them, we're talking about 2018. The planning permission was August 2018, and the licence also a little bit later in August of 2018. So certainly recent. Now, we've put in, on behalf of Mr. Randall and Mr. Duffy for Faith in Strangers, an extensive statement of truth, which has the declaration of truth and has been signed. I'm not going to seek to repeat all of that, so I would ask that you take account of all of that in your own time. The exhibits that went with that appear to be very lengthy. They are predominantly composed of letters of support, of which I will be saying more in due course. Many of the council didn't accept the letters of support. There was over 100 of them. They came in November. Faith in Strangers has been trying to get hold of them ever since, and I think we got them either on Friday or Monday, and that was after we indicated that we were going to have to submit a Freedom of Information application or an Environmental Information Regulations application to get them, which is quite wrong. Some of them should have been before you in any event as relevant representations, just as these residents. Many of them, if not all of them, should have been before you in the exercise of your public sector equality duty. And I will be coming back to that later, because that has not been exercised in this case either. Faith in Strangers was not granted planning permission as a nightclub, and if what the residents are saying were correct, they'd be in breach of their planning permission and there would be enforcement proceedings from your planning department, and there is not. That is because they're not doing anything wrong. The workspace that you will read about in the many, many letters of support, the different people who use it in different capacities during the day, during the evening, during the night, it is exactly as it was intended to be, and it has work areas within it. I was there a little earlier today. It's all set out with the work units. Those are not moved away on an evening to create a dance floor or anything of that sort. The space is set up the way that it was intended to be. And the many, many letters of support that you have received, and I don't know if the committee's had any kind of realistic opportunity to read or absorb them in the very short time that you've had them, but bear in mind the council's had them since November, will give you a very good flavour as to what these premises are all about and what they do on a daytime basis and a nighttime basis, and also, importantly, the value of these premises to the community at large. And I appreciate that the Cliftonville residents have talked about themselves as a community. There is a wider community that is engaged here, which is very important, so important, in fact, that it has been commented upon for relevance by the Court of Appeal, and I will come back to that later as well. So the two sides of this story. There was no issue so far as the Faith in Strangers proposal was concerned until Ms Wilson Powell and Ms Pritchard moved into flat 3. There had been no complaints prior to their complaint in the autumn of 2019, shortly after Faith in Strangers had conducted some of their early events. They have clearly been writing to the neighbours, and that is evidenced in your pack. We've had some reference by Mr Rees-Gay to lobbying. If writing to people who work and use Faith in Strangers is lobbying, then so is writing to your neighbours asking them to join with you in a campaign of complaint against the premises. It's the same thing. There were no complaints to environmental health before the flat 3 occupants moved in. Perhaps more tellingly, there was no objection to the licence, which included the music, live and recorded, and the speaker specification, and the sound attenuation, and there was no objection to the planning permission application either, which is a very good indication as to any level of concern that residents may have had, and they will now say, well, everything has changed. Well, no, it hasn't. The application set out the specification for the speakers. It was all there, and it was assessed by the environmental health officers, who were consultees to both the licence application and the planning application. More importantly, Mr. Ranatunga has mentioned to you the history of this site, which was relevant, you know, to the noise abatement notice and whether that could be sustained or not. And the answer was not, because this was not and never has been a tranquil residential area. The use of this area is characterised, and that's an important word in noise nuisance, by a nightclub use for some 40 years. It's the established lawful use of the site that will predate most, if not all, of the residents who have chosen to live there. Starlight for some 20 years, Frank's for 20 years after that. There were complaints about Frank's, that's on record. You will see within the pack that you have, in the representations that have been made, that there's some colloquial and anecdotal reference to Frank's and how it used to shake the building. And you've heard from your licensing officer perhaps some of the indications as to why there weren't more complaints, and that is because Frank bought up the flats. The flats immediately above for the use of his staff. Now it's been suggested that some major structural reconfiguration has occurred between Frank's incumbency and the Faith in Strangers, such that there was a spare floor of some description. Absolutely not the case at all. There's been no restructuring of that sort, that there was no noticeable change in the structural integrity of the building. I will talk about the attenuation that Frank's had, however, because that is an entirely different matter. But in terms of prior complaints, some of the earliest awareness that Faith in Strangers had about the complaints that were coming forward from Ms. Wilson-Powell and Ms. Pritchard, which, to set the record straight, were aggressive in nature, were accompanied by their attendance at the premises on the outside through the car park with their mobile phones against the wall of the building in order to be able to Shazam the words of the songs, and they are on CCTV doing it, and that CCTV is available. So there are two sides to this story, and so far as the occupation of Flat 3 is concerned, it is a matter of fact that the occupants moved in 2019. The searches on their property would have revealed the planning permission and the licence authorisation. It is a second home. They do have a home in London, and I will be making reference to the fact that this is a classic agent of change case, which is a very important factor. They have chosen to go to the national newspapers. This story appeared in The Sun yesterday or the day before. Faith in Strangers declined to comment because they said it might prejudice these proceedings. Clearly the residents did not share that compunction. The sound insulation, let's look at that as a technicality for a moment or two. To the extent that any of the residents, and I think it's mainly Mrs. Walker in flat 9, purport to be able to make a like-for-like comparison between the sound attenuation that was in Frank's previously and what is in for Faith in Strangers now, that is an inaccurate analysis. even to the point of trying to interpret photographs. And as I say, this is a highly technical expertise. There were 3 sets of acousticians involved in the attenuation that was put in for Faith in Strangers. You will see at page 170 of the Faith in Strangers exhibits Kelvin Joy from Techno Timber Construction, who gives a detailed blow-by-blow account of the acoustic attenuation that was installed for Faith in Strangers. And the acousticians actually reported in the course of the licensing and the planning proceedings that the attenuation such as it was that had been in situ...
Sorry to interrupt, what page was that? Sorry, it's not...
170 of the Faith in Strangers exhibits. Such attenuation that Franks had was degrading and crumbling and to a certain extent collapsing to such an extent that it was actually making the situation worse. This is a difficult building to attenuate because it is concrete and the residents...
Many apologies, sorry, 170's Michael Kill, Together We're Stronger.
I didn't interrupt Mr. Eastgay. I wonder if I might be allowed to continue unabated.
A page, I'm just trying to find it, that's all.
I didn't interrupt you, Mr. Eastgay. May I be allowed to continue, please?
But if you could show me, if you could refer me, I'm looking
Then
at
I've
page
obviously
one.
taken an incorrect note, and no, I'm not going to be able to tell you right this very minute without going through it myself. It's quite an unattractive tactic, if I may say so. The residents have mentioned the concrete elements of the building, and particularly the pillars, which do conduct noise. There's 2 elements of noise transfer, as you may be aware, airborne and structure-borne. So far as the concrete pillars are concerned, one of the elements of the attenuation put in by Techno Timber Construction was to insulate and isolate the concrete pillars. And if you were to go into Faith in Strangers, you'd be able to see that. There is several feet of acoustic material wrapped around the concrete pillars in order to prevent the upward transmission of sound through those concrete pillars. Franks did not have that. It also did not have a number of the elements that have currently been installed, including the dropped sound ceiling. Additional works have been done to Faith in Strangers beyond that which was required by the Planning Commission licensing. They have put in insulation into a fire exit area. It is not correct to say that the only way to attenuate a building like this is to put a box within a box. Sound attenuation is a highly complex matter, and this was very professionally done at huge cost. It's cost in excess of £50,000 for Faith in Strangers to put in the noise insulation that they have done, and they've done more than they were required to do and not less. And Environmental Health and Licensing do not contend to the contrary. They obviously went out to examine and assess the works that were done. They obviously had to sign off the planning condition. They did so. They signed themselves off as satisfied with it. So the council has essentially approved the Faith in Strangers sound attenuation twice, and were instrumental in saying what it ought to be in the first place. I'm going to ask the gentleman in due course to comment on the speakers themselves. They're in a better position than I am to do so. But the speakers are not, as the objectors are alleging, either in terms of capacity or description. May I ask you please to take a closer look at the withdrawal letter from Environmental Health from Miss Amanda Berry that came out on the 2nd of December of 2021. Mr. Ranatunga has referred to parts of it. I'd like to emphasise the line that says...
Sorry to interrupt again, is that in the papers? Apologies, I don't think I've seen that letter. Could you just refer me to
I don't know where it is, Mr. Eastgay. I'm sorry. It will be in the papers, yes.
It is in the papers?
Yes, it will be.
Mr. Ranatunga, do you know where it is in the papers?
This is the noise abatement withdrawal notice on the 2nd of December 2021. Mr. Ranatunga read it out earlier. As I was saying, the line reads, although the council had received several other complaints of this nature from residents of Cliftonville Court, our investigations had not proven a detriment to their amenity. That was the reason given to Faith in Strangers as to why the review was withdrawn and the noise abatement notice was withdrawn. And that is the letter that Mr. Ranatunga referred to. Now, this is important because that letter came in December of last year. The representations to which the residents speak to you today came in November of last year and were based upon the complaints that they had made to Environmental Health prior to that. You've seen, not that you should have done, but you have seen the review application and the environmental health visits to various flats and sites. Mr. Rees-Gay, as might be expected, read out the ones where the officers said they did identify something that they would describe as a nuisance. There are more, again, within that pack that I don't have time to take you to line for line, but I'd invite you to look at them if you're going to look at it at all, that say they did not identify a nuisance. So in other words, residents had called them out and they assessed what it was that the residents were listening to, and they did not assess it to be a nuisance and wrote that down on their visit form. And in the same way, that was the decision that was taken and was communicated to the club as to why the review and the abatement notice were withdrawn, because despite the complaints that the residents were purporting to make and despite the things that they were saying, the professional objective assessment of the situation was that it was not a nuisance. And that is why this case is so finely balanced in that description as to what is a nuisance or not. The officers who attended gave their conclusions upon it, and that has been the outcome of those proceedings. It would be incredibly difficult, if not impossible, for Environmental Health now to go back on that position and serve a further noise abatement notice, having so recently withdrawn one, or indeed to serve a further review so shortly after these proceedings. Furthermore, you've heard from Ms Berry through Mr Ranatunga today that although certain people were complaining to the Environmental Health Department, when offered intervention by Environmental Health for some sort of investigation, they declined to do so. And I invite you to take that into account as well. The further matters that the objectors have raised in terms of people noise outside, whether patrons or drunken persons or noisy dispersal or bottles or fights or public urination or anything of that sort, again was something that was discussed and considered by Mr Brown and discounted as being something that could be laid at the door of Faith in Strangers. The connection between them is simply not there. And for the reasons that the gentlemen that Faith in Strangers have put into their licensing statement, that this is a thoroughfare and very many people walk up and down it on their way to and from many different places. And although there are episodes of antisocial behaviour, it's not accepted that it emanates from these premises and it's not accepted that they are responsible for it. And it is important to note that that has never formed part of Environmental Health's concerns. They did not put it into the noise abatement notice and it has not substantiated any of their complaints against or their dealings with the premises. So that's a very difficult one to pin on these premises, and it's not accepted at all. At least one of the complaints from flat 3 that went to Environmental Health was made on an occasion where Faith in Strangers was closed. The noise was actually coming from a completely different set of premises that were conducting a wedding at the time. This is an unprecedented set of proceedings in my experience. It is unheard of for an MP to appear before a licensing committee of this sort in such a partisan position. I have some deep concerns about the letters of support that the Council has rejected. Many of those supporters have written to Mr McKinley asking for his support and input for their position in this case, that the response that they had back was that it was not his responsibility to get involved. And I have to draw that to attention because he clearly has taken such a strong line in terms of being here and also in terms of his comments in the press, which I would invite the committee, should they have read them, to completely disregard. When he talks about residential assets in terms of their homes, of course, Faith in Strangers is also an asset. This, I mentioned, is a classic agent of change case. This is a situation where, in terms of the most recent comers to the block, to the flats, this is akin to moving to the countryside next to the church and then complaining about the church bells. The freeholder who has granted the lease has put to the newer tenants who've been incumbent since the freeholder bought, which I gather was a bidding competition with Mrs. Walker at flat 9, which the current freeholder prevailed in. There are 3 clauses within the leases that the most recent tenants have taken, indicating at clause 10, 11 and 17 that they're not in a position to complain about the music and the entertainment use of the premises underneath, because it was always envisaged that those uses would have to coexist. Those clauses in the leases have been disregarded. It is also true to say that the freeholder has offered to buy the leases of those who regard themselves as the most affected, and as you've heard briefly touched upon, those offers have been rejected. This is a lawful use of this site going back for very many years in terms of what the premises are entitled to do even before Faith in Strangers moved in. There is no representation, I've indicated to you, from planning. I should also mention there's been no representation to you from the police, who would have something to say if they regarded there being any antisocial behaviour locally that was connected to the premises. I'm going to make a couple of final comments in relation to issues that I don't believe have been taken into account in presenting this case to the committee, and this may be a huge disservice to the committee. You have one paragraph in your agenda pack alerting you to your public sector equality duty. As things currently stand, I have grave concerns, and I raise it as such with this committee, that duty is not being properly exercised. You may appreciate what your duty involves, which has been set out very clearly in the case law. I need only read a line or two about it. In individual decisions, a decision maker must assess the risk and extent of any adverse impact of their decision on any persons with protected characteristics. Now, one of the problems of not receiving all of those letters of support in good time is that you, I hope this is not correct, but I fear that it is, have not had an adequate opportunity to go through those letters to consider what they are saying about the impact of any steps taken against faith in strangers upon persons with protected characteristics. The case law says that general regard to issues of equality is not the same thing as having specific regard to the statutory criteria, and public decision makers must be properly informed before taking a decision, and if relevant material is not available, there's a duty to acquire it, which makes it all the more concerning that all of those letters of support were not placed before you, because many of them talk about the way in which Faith in Strangers upholds their interests as persons of colour, or persons of minority descent, or persons of LGBTQ plus indication, or anything of that sort, or any of the other protected characteristics. It would be expected to be seen in a decision of a committee of this sort as to how they've taken those representations into account when deciding, if anything, what steps they are prepared to take. I'm also going to refer you, and your legal advisor will be aware of it, of paragraph 42 of the Hope and Glory case in the Court of Appeal, in which Lord Justice Toulson gave a 360-degree overview of the considerations that were relevant to a licensing committee such as yourselves. And one of the key considerations that he set out was the importance to the local economy, the importance to the visiting public, the people who actually use the premises, and the importance to the licensee themselves. Sometimes it's presented as if running a business were a dirty and underhand thing to be doing. It's quite the reverse, as I hope the letters of support make abundantly clear, and the contribution that Faith in Strangers makes overall to Margate. The support from the Music Venue Trust and the Nighttime Industries Association I generally highlight. And can I conclude my remarks by saying this? The Faith in Strangers, Mr Duffy, Mr Randall, have always and will continue to work as closely as possible with environmental health, with licensing and with any other authority with whom their cooperation is required. In the course of these proceedings, it has been my advice for them to conclude these proceedings and conclude the court proceedings, because they're in a litigation situation, and that is not a good time to be engaging in open discussions and negotiations with particular outcomes. That does not mean that they are refusing to cooperate or to discuss what it is that environmental health would wish to discuss. They maintain a best practicable means position. They have done everything that they can do, going above and beyond what the authorities to date have required of them. They have put rubber stoppers on the bottoms of chairs. The photographs are there for you to see. They have sought to address hand dryers and any noise that might arise from them. They have acoustically attenuated a fire exit area that they were concerned might possibly be a route of transmission. They've done a number of different things. They will continue their cooperative discussions once these proceedings are concluded. Those things were not part of the noise abatement notice, I have to highlight. Hand dryers and chairs were not in the noise abatement notice. It was purely music from machinery, which is a slightly unusual way of putting it, but that is what the noise abatement notice said. So clearly, so far as environmental health were concerned, that was what they were focusing upon. But Faith in Strangers completely understand their responsibilities to try and ameliorate any reasonable complaints that are being made against them. Unfortunately, and this is an unfortunate case, not everything that has been levelled at them has been by any standards reasonable, and on certain occasions quite the contrary. And this is going to be a very difficult case to bring to a final conclusion by the sounds of things. Can I ask Mr Randall and or Mr Duffy to give you a little bit more information on the speakers specifically?
That's great. So yeah, if Mr Randall, Mr Duffy and Mr Ford would like to add to that.
Thank you, Madam Speaker. I'm going to talk briefly about the speaker system, just to clarify, because we feel there's been some mistruths or misunderstandings around what exactly we have installed in the building. There are essentially two distinct systems. The first is the Function 1 sound system, which comprises of several small speakers that are around about this size. I think we've got the size here. They're 35 by 25 centimetres. They're all on acoustic rubber isolators that mean that their vibration into the structure is negated by that. And they're spread throughout the building rather than what a nightclub or a solely music venue would do, which would be to have one source of sound. We've spread it throughout at a lower level, so that wherever you are in the building, the music can be played at a lower level rather than loud from one source, if that makes sense. Then on top of that, the additional system is the Klipsch, which is a domestic hi-fi system with a valve amp. I noticed that Klipsch have been picked up on their tagline. We don't choose sound systems based on their advertising. The system is typically used for more of a listening experience with earlier on in the evening with jazz and soul and so forth. It's not used later on in the evening in any case. I think is there anything to add to that, Jerry?
Can you hear me? Yeah. No, the only thing is about the Frank's soundproofing I wanted to bring up is that structure made things infinitely worse. It wasn't decoupled at all. So it was a wooden structure drilled straight into the concrete. It had no rubber isolation, had nothing. It made things worse. Our acoustician said that, and obviously Donna picked up on the water damage as well. So I think actually the freeholder actually took that structure.
It was derelict at that point.
Yeah. But yeah, I mean, we were told by professionals that would have made the scenario worse. Hence why I guess Frank Thorley had to buy 5 or so of the flats above.
Madam Chair, I don't think Mr. Ford wanted to speak, but we do have the councillor here who is one of our witnesses and down on the Regulation 8 notice.
Did you say your councillor's talking for Mr. Ford?
No, this is Mr. Ford here, but we submitted a Regulation 8 notice with 4 names on it. It's Mr. Yates, isn't it? Councillor Rob Yates was one of those names.
Okay, that's great. Thank you.
Thank you very much, Chair, and good afternoon, everyone. My name's Rob Yates. I'm a local resident in Thanet since Margate since 2017, and the councillor for Margate Central. Margate Central doesn't specifically cover this area, just for that information. And I've been that councillor since 2019. So during the pandemic, just to put all my cards on the table, I want to be as transparent and open as possible. I worked as shadow cabinet for finance within the council, and within that role, supporting businesses, ensuring they were connected with the right business grants throughout the pandemic, and finding a way to keep Thanet's economy alive. Unfortunately, I was not around when this venue is Frank's nightclub, so I cannot easily speak to that. So over the pandemic, I found Faith in Strangers to be an invaluable workspace to myself, because we were being told to work from home. And I found the opportunity to work there. I have attended many of their evening events as a customer, and have become to know the hard-working business owners, Richard and Jeremy. Just say firstly, that has been portrayed throughout this evening as a nightclub. So apart from one live music event where there was predominantly people standing, every other night I've been to, and probably been to about 10 to 15, you do see people sat down. They're sat down at the workspace of like seating areas, and the music is such that you are able to easily talk to each other through the music. I just want to say that the vibe is not so much a nightclub, but more of a fancy bar. And quite often on events I've been to, specifically over the last few months, there haven't been enough customers to keep the venue open till 2 in the morning, so they have been closing early. So today I'll be briefly explaining the licensing objectives that I put forward in my submission. I briefly then want to make some wider points highlighting my support for Faith in Strangers and the benefit to the community of Thanet and the wider economy that they do make. So firstly, just going on to prevention of crime and disorder. So as I've highlighted, they've got a doorbell, checking people in and out. They've got security on Friday and Saturday evenings, making sure that people are behaving themselves as they come in and out, and they will check on people as you're outside, because I do go outside when I'm smoking at the venue, because I'm not allowed to use the balcony based on noise-specific issues that they want to avoid. According to Faith in Strangers, the only time the police have come inside is after a woman is found to be hiding from domestic abuse, so they've come into the night to avoid that. As highlighted a few times during the fit-out of the space, the TDC Environmental Health Officer witnessed the insulation measures. Christopher Brown, sadly, he seems to no longer work at TDC, as they feel like his involvement would be beneficial to the parties. So I do completely understand noise issues, and I've lived in Arlington House with single glazing outside the front, see it by the roundabout, woken up all times of night, so I do understand it, and especially with the scaffolding outside the building during the daytime, which you do hear within Faith in Strangers, the work's going on there. I can only imagine the frustration there must be to have noise in the evening as well. Going on to the concrete pillars, I actually measured up the pillars, the size of them, because I wanted that, because that is a key thing that they have done with noise insulation. And the pillars, according to the records, According to what Richard told me, they were 30 centimetres, and you can see that in the picture. They are very narrow pillars, and now they're 85 centimetres, and I witnessed that being measured with rock wall insulation inside. So that's on the pillars. The floor, the new metal floor, has isolation in it to dampen the noise, from what I'm hearing. I believe there was no dampening of that noise at Frank's time. The ceiling of Faith and Strangers, so again, already mentioned, F1 Sound are involved, and the council involved in the creation of that kind of noise dampening system. And I have seen with my own eyes the double glazing that they have put into small windows that are in the top, and that was done after so initially they just had double glazing, but then they had secondary glazing put in once some noise issues occurred, from my understanding. But I've seen the secondary glazing, so it definitely exists, and that secondary glazing exists throughout that structure. So I think that's important to notice. Balcony usage. So I love standing outside, looking at the sunset, having a drink, but they'll only allow drinking in the balcony until 10 o'clock due to noise issue. 9 o'clock, sorry. I put 10 o'clock in my submission though. And again, they won't allow that for smoking, even though I'm a smoker. I couldn't convince them of that. Speakers. So I think we've gone through speakers. I've highlighted the noise, the Dyson hand dryers. I'm not a fan of Dyson hand dryers, and they are installing some additional insulation, I believe, around that. And that sounds like it's been completed. I'd just like to highlight that compared with other nightclubs, I don't use that term loosely, I think it's more of a bar. Compared with Kabuki, Margate, or the nightclubs in Canterbury, I find it much too quiet in there. And obviously, like, I've been to a few nightclubs in my time, but I'm surprised they don't increase the noise to have more dancing, because most of the time people are sat down. So that's my personal view. Going on to protection of children from harm, they've got an age verification policy. They keep a logbook when they reject people at the door. Public safety, first aid kit is under the bar. They follow strict measures for alcohol to ensure they don't pour over. 5-star food and hygiene rating. Kent Fire and Rescue have praised them according to the owners, and they've successfully held events without incident, including Pride events. But I'll go on to that briefly. So that's just my overview of what I've submitted. However, I think we're allowed to just discuss wider issues briefly. So, firstly,
Councillor Yates, you've exceeded the 5 minutes now.
Okay.
You wrap up.
So did MP McKinley. So it would be but it would be fair for him to. Thank you.
Okay, thank you very much. I'm wrapping up. So, yeah, we are seeing businesses struggle in Thanet, and I do have serious concern that if one resident can start a review of licensing planning, opening up licensing planning conditions, then other businesses across the area will feel nervous and will feel scared by that. As already mentioned, I think it's important to note the Environment Health have formally kind of withdrawn from today, and that's I think a key point. But just that go on to what Mr. McKinley said finally about what Faith and Strangers has done for the community. So they've hosted a Power of Women live stream event during the pandemic. They've fundraised for Our Kitchen Food Club. They've hosted a family-friendly technology meetup. Hosted an evening skate park launch as part of the Margate Town deal. They've had queer DJs perform, and they continue to work with the community of Thanet. So for all those reasons, I hope the committee do not open up the full licensing review, as to do so would go against the Environment and Health recommendations in front of you. It could be seen as a threat to other late night businesses across Thanet who have really struggled during the pandemic, and could result in further legal action. Thank you.
Thank you. Mr. Ford was going to.
It was only a very brief procedural point, is that we're mainly here to observe and advise, but we were one of the organisations that submitted a representation within the time. We put quite a detailed submission in, which our letter has been included as part of their evidence, but we've never received any acknowledgement or any explanation from the local authority of why it wasn't included, or even acknowledging its existence. So I think that is quite a significant procedural concern, because there's us and another 135, I think, organisations that didn't get any response. And my understanding is that anyone making representation on behalf of the local authority got sent a pro forma, where we didn't even get that opportunity to actually to look at our representation if they felt that it didn't fit some of the criteria. But we did do quite a detailed submission, and the main purpose of the Music Venue Trust is to work with venues and local authorities and residents to try to come to kind of resolution. So we are trying to work with the venue, and we will continue to advise the venue, but we are quite disappointed that such a simple procedure wasn't followed.
That's noted. Does the licensing team have any questions for those representing Faith and Strangers? No. Does Environmental Health have any questions? No. Mr. Rees-Gay, do you have any questions?
Thank you. Yes. Sorry, Ms. Clovey. You stated, and could you please explain why a noise abatement or a review couldn't be served so soon just because they've been withdrawn if the operator changes his modus operandi, fires a salvo and keeps operating at loud music? Why would it not be appropriate for a noise abatement or a review not to be served? I don't understand the logic.
I wasn't talking about a hypothetical or a speculative situation where changing tack or changing operation. I was talking about the reality on the ground.
So disputing the evidence that's been put before you today?
I'm sorry?
So you're disputing what has been said by the residents today?
I had hoped that I had made that abundantly clear.
Thank you. Sorry, for Mr. Randall or Mr. Duffy, in terms of the speakers, obviously I don't know speakers, but obviously you've heard, and it's been witnessed within the reports, that lyrics can be heard from songs in the residence. Do you think that speaker system works?
Does it? What do you mean work?
Well, as in, does it
isn't
stop
that
sound
what this is all
attenuation?
about?
Does it stop it travelling? Is it a system that works and means that you can function as a nightclub and not?
I think the point is that it could be a hell of a lot worse, and we've designed that system with that in mind to try and stop the transmission.
Thank you.
I mean, they're 35 by 25 centimetres. That's not a normal. I think we got referred to as a festival sound system. I think a festival sound system would usually be a few metres high, and it would have 20 speakers or so.
That's lovely. Thank you. No, that's all I've got. Thank you.
Yes, Craig Pinnock's residents who submitted representations, that yourself included, Craig.
Thank you. Just really to Miss Clover, as she sort of mentioned me by name in
It's
her.
Clover.
Clover, I'm so sorry. It's Clover, as she mentioned me. You mentioned church bells, which is an interesting point. We had a noise abatement order in Sandwich recently.
Sorry, is this a question?
It is. You said people would move into an area, complain, and have to put up with it. Well, exactly the same happened in Sandwich, and the church bells were closed down or stopped. Now, you say I've acted in a partisan way. Can I just...
Sorry, I didn't understand the question about the church bells. Could you put it again, please?
Yeah. You said that people...
So what was the question?
The question was, you said it doesn't happen. Well, I'm afraid it does because it happened locally.
No, I didn't say it didn't happen. I said it does happen, and it's wrong.
Okay, well, we've clarified the point between us. That's great. You accused me of acting in a partisan way. Now, it is unusual. I'm sure it happens with other MPs.
So is this a question?
I want to clarify the point that you put to me. You put to me that I've acted in a partisan way. I will put a question then. You rather ingenious, with great ingenuity, I must admit, and I really do commend you for it. You wove
Will the
into
question
your
be coming soon?
It is. You wove into your arguments Equality Act 2010 and the Public Sector Equality Duty. Can you just answer to me, do your clients have disabled access, allowing wheelchair access to their premises?
That's not relevant to a licensing hearing.
Okay.
When you're not talking, can you turn the microphone off?
It's not a relevant point for a licensing hearing. It's not
Well,
one of the
that's
licensing
fine.
objectives.
Don't answer it then. That's absolutely fine. As part of your submissions, you said officers did this, officers did that. Things didn't raise to the threshold that was required. are you actually saying that the officer's word is the highest standard that people should go along with? And are you calling all of these residents in making their complaints therefore liars?
I think my submissions have been abundantly clear, and I don't have anything else to say about it.
No, that's fine. Thank you.
Do any of the other residents who submitted representations have any questions for those representing Faith in Strangers?
May I ask a question? May I ask, do you believe that it is reasonable for the residents of Cliftonville Court, including the children and toddlers, to be subjected to the noise nuisance that you create?
I'm sorry, that's not a question for me. That is a question for the committee. That's not an empirical question. That's a judgmental question, and it's for the matter for the committee. It doesn't matter what I think.
Sorry, could you repeat that question? I didn't catch that. Sorry.
I was asking whether or not Miss Clover felt that it was reasonable, which I appreciate I haven't phrased particularly well, that residents would be subjected to the noise nuisance that we are being subjected to. I really does beg a belief to me. I don't quite understand where the rules of common decency have gone. Why would you set up a business that puts us all through this and sit there and defend it? I'm just curious. Sorry, right.
To ask questions to them. Yeah, they can. It doesn't say that on here. So, okay. Sorry. Do members of the committee have any questions to ask? Sorry.
Thank you, Chair. I've got one question to ask Mr. Reynolds and Mr. Duffy. I've heard you talk about all the singing and dancing, installation and advice that you've put in and asked for. Have you actually ever asked the residents if you could come up to their flat when the noise is being made so you can hear it?
Yes, we have.
Councillor Rogers. Sorry.
I asked, have the Mr. Duffy and Mr. Reynolds been up to hear the noise when it's happening? To which he said yes.
Yeah, we just to clarify, we've been in.
How loud he thought he was?
So we've been into flat 3 with Miss Pritchard and flat 2 with Mary Strachan, who's sadly no longer with us.
Sorry, can I just say you didn't come into our flat when you're having a night. You've never been up to one of our flats when you're having a night on. And Mary died last April before you opened or reopened.
We had opened by the time we went to visit Mary.
Also, we played the sound as loud as we thought we would ever go, probably louder. So it's kind of, that doesn't really make sense. But you haven't. I mean, we've been up numerous times. And the last time we came up, we got accused of, we're not... I think the relationship broke quite early on, didn't it?
Unfortunately so, it appears, even before we moved in. Sorry. Please, may I ask one question of Ms. Clover? You suggest that I was shazamming a track on the ramp. Could I ask how you know, or why you think I was shazamming a track?
It's on CCTV.
May I make a point of clarification on that? I had a complaint from a resident here, Jackie, that from top floor she could see strobe lighting. I was filming that. I did at the same time make a recording on the noise app. The environmental health team will be able to confirm they've had one recording from outside the premises, which I marked very clearly as being outside the premises. I only took that because I was recording the strobe lighting at the same time. One occasion.
Members of the committee, have you got any more questions? Councillor Rogers.
Thank you. If this isn't a nightclub, can you tell me why the DJ that's coming obviously on Saturday says he's going to rip the roof off? That sounds pretty heavy to me.
It's just an expression. It's a way to generate excitement around someone who's coming to play records. It's obviously not. There's no tearing the roof off.
I've got a question. When you initially put in your application to planning and licensing, was your intention at that point to have like an arts venue, which was basically to have academic speakers, poetry? I mean, and I understand like the workspace as well, because all of that is like amazing. Only because today, when I look on your Facebook page, there's lots of DJs listed that are playing techno, jungle. I mean, these are the kind of like nightclubby type of DJs. So it's like a hybrid, you know, like nightclub, you know, 1 minute, then sort of arts workspace the next. So I was just thinking, you know, like it was a bit confusing, the original licensing and planning application. And I was just wondering if the intention was always to have these sort of like heavy techno electronic DJs right from the beginning.
Typically, we don't really have techno, and we've never had jungle, but we do have DJs on Fridays and Saturday nights, and we consider the musical aspect an aspect of art and culture, and we see music as the foremost art of the time. So we refute the idea that it couldn't be included in that. We've held Margate Science Festival, as Rob mentioned. We did a whole festival around the Margate Power of Women brand. We've done spoken word poetry, we've done talks, we'll continue to do that. It's part of a holistic cultural programme, but as is mentioned in our statement of truth, all of those aspects don't generate the funds to cover the costs of running a building like that, which is why Frank's nightclub and Starlight before just relied solely on the DJs much more frequently than we did. Really, it's mostly a Friday and Saturday night thing with the occasional. I think the Wednesday night event they're referring to, I think, was a office Christmas party. So, yeah. Do you want to add anything?
Sorry, can I just add? I guess the other thing to bear in mind is that this has taken up all of our time, and DJs are very easy. They're very easy to put on. They don't take too much production and all the rest of it. So we've got debt. I mean, we've got an innovation loan from County Council. We have lots of debts that we need to cover. DJs are very simple. It's one person. They're mainly locals, so we don't even have to put them up or anything. We don't have to pay for travel. Bands and all the other arts and culture take a lot more programming and a lot more detailing. So if we got ironically, if we had our energy and time to do that, we would have put on a lot more of the, you know, spoken word or whatever. But that's another reason why that's happening, and we've programmed that.
Madam Chair, may I just clarify a couple of things that you have said? I'm not sure where the techno and jungle DJs...
Sorry. Yes, I was actually going to clarify that. The techno and the jungle DJs are actually how they're described on the Facebook website for the venue.
That doesn't necessarily indicate what they're playing on the night. My instructions are, if everybody's quite finished.
Sorry, so they're separate DJs for like different nights, and those DJs underneath it states what genre of music they play.
We haven't done a single techno night. There might be a night where a techno record gets played, but it's not the whole. It would never be the whole night.
Well,
techno's actually quite.
You wouldn't have to look back very far. I mean, I'm talking about if you went onto the Facebook page now, you could find that very easily.
Yeah, I'd say predominantly our the music we play would be in disco and soul and house, jazz. I don't think there's. I've never heard a jungle record played in there. Maybe the occasional techno, but it's probably more likely to be ambient techno or what they call drone techno, which is a much more slower paced affair.
Madam Chair, can I also raise this point in terms of the cultural offering? You've got a number of letters of support in the 135, 137 letters of support that came in that described the cultural events that people have been involved in. Can I just clarify at this point in time whether the committee have read those letters of support?
Yeah, I did hear you referring to that earlier on. We were sent all of the letters, so yes, we have had the opportunity, and I have read through the letters of support. You know, and also I can, you know, like clarify that most of those letters were about, you know, how good it, you know, the overall it is for the community, and you know what a good establishment it is, etc., and how it's well run. Obviously, what we were looking for was like noise nuisance.
There are numerous references within those letters, and I'd be happy to give you the page references if need be, that talk directly to the licensing objectives, and those letters, as Mr Ford has indicated, should have been before you as relevant representations. But in terms of the specifics of what people are saying, as I've said, it's not to be disregarded because they go to your PSCD.
Do the committee have any other questions for the representative of Faith and Strangers? No? Okay. All right. So, summing up, I would now like to ask each party to sum up and make final representations. Mr Ranatunga and the Environmental Health Team, do you wish to make any final comments?
No, Madam, I've set out our position earlier.
Okay. Thank you. Mr Eastgate, please can you make your final comments up to 15 minutes.
No, thank you, Chair. No, I won't need that long. Just so that you're aware and the committee's aware, I hadn't been put on notice of the protective characteristics argument that Ms Clover's raised today, and therefore can't respond to that. In terms of Ms Clover read out the Hope and Glory case, and I actually happen to have it and I can hand up cases, but just so it's not disingenuous, I'll just read the full transcript. So 41, as Mr Mathias rightly submitted, the licensing function of a licensing authority is an administrative function. By contrast, the function of a district judge is a judicial function. The licensing authority has a duty in accordance with the rule of law to behave fairly in the decision-making procedure, but the decision itself is not a judicial or quasi-judicial act. It is an exercise of power delegated by the people as a whole to decide what the public interest requires. That was 41, and then 42. Licensing decisions often involve weighing a variety of competing considerations, the demand for licensed establishments, the economic benefit to the proprietor and to the locality by drawing in visitors and stimulating the demand, and the effect of law and order. I think that's what Ms Clover said. However, she missed out the impact of the lives of those who live and work in the vicinity and so on. Sometimes a licensing decision may involve narrow questions, such as whether noise, noxious smells or litter coming from the premises amount to the public nuisance. Although such questions are in a sense questions of fact, they are not questions of the heads or tails variety. They involve an evaluation of what is to be regarded as reasonably acceptable in the particular location. In any case, deciding what, if any, conditions should be attached to a licence as necessary and proportionate to the promotion of the statutory licensing objectives is essentially a matter of judgment rather than a matter of pure fact. Moving on then, Chair, please. As per section 1119 of the section 182 guidance, all options are open to the committee today, including, we would say, revocation due to the behaviour of the operator and their unwillingness to engage when clearly there are noise issues. For clarity again, just to confirm, my clients have been, obviously the agent of change principle has been raised, my clients have been in their flat for 2.5 years. There were no issues until it was transferred to a nightclub, and therefore that's when the complaint started. So my clients were resident in the premises prior to it becoming a nightclub. Not 2.5 years prior to it becoming a nightclub, but were in place. At no stage are they trying to stop any of the co-working space. If it was as per the planning application and the licensing application, there'd be no issues. We stand by the fact that the operating style has clearly changed, and obviously you've heard much discussion. Councillor Yates even referred to it as a nightclub himself.
No. Objection. Objection. I said the vibe was not a nightclub.
You said the vibe was a nightclub, but you...
I said more like a bar, and you've just misrepresented my words. Sorry, I had to make that correction.
I'll take that back. There were no complaints prior to this transition. We say that there clearly is a public nuisance. That residents, as you've heard, and as in the written correspondence, directly affected by Faith and Strangers nightclub operation. Shielding behind Frank's and planning simply doesn't wash, as it doesn't address the issues. Rather than attempt to mitigate the problems, they've fought at this hearing and at every opportunity to work against the residents rather than working with the residents, which we say is against the promotion of the licensing objectives. It's not just the loud noise, but also the reveller noise. In terms of, we did try and report it to the police, but they said it was an EH issue, so that was mentioned as to why we hadn't been to the police. We had been, and they said it was an EH issue with the revellers outside. But it's also the furniture and the hand dryers. As you've heard, since December and January, when EHO have become re-engaged, they've indicated that there are high levels from recent test results, and that they have concerns. There is an issue. You've heard from the residents. Has the premises done everything it could reasonably expected to do? And we would clearly say no. In our eyes, they've chosen a business plan over the residents. And for that reason, we would request that all licensable activities be reduced to 2,300 daily. This will eliminate the noise transmission and indeed the noise from the revellers. The electric hand dryers be replaced with a system that doesn't create noise. That all furniture have rubber socks. And that, importantly, that you remove the Live Music Act exemption with the deregulation of live and recorded music from before 2300, and that a noise limiter condition is added to the levels to be set and agreed with environmental health. It doesn't cause a nuisance to my clients. Chair, those are my submissions. Thank you.
Do any of the residents wish to make any final comments?
Been said, but oh, sorry, Trowbridge, we've gone.
I hope I'm not out of order saying this, but I just wondered.
Sorry.
Oh, sorry. Oh, do you want me to say?
No, sorry, we had
The thing about a business, these gentlemen then losing their business, I may be wrong, but I understand that they receive grants from the local authority because they're a community centre, like it's a community space. So if that's true, then I'll say that losing a music licence would not be that much. They've got like another business to fall back on. That's all I wanted to say.
Ms Clover, can you make your final comments, please?
Yes, thank you. The point about grants, you can't live off grants, particularly throughout the coronavirus crisis. They have been life-saving, not business-sustaining. We're talking about business viability, and this is nothing new. Unfortunately, we're different. Spoken word and poetry and arts presentations of different types are not sufficient to sustain a business. If we want them at all, we have to supplement them with enterprises that make money, and that is exactly what Lord Justice Toulson was talking about in Hope and Glory. I'm grateful to Mr Eastgate for reading out the paragraph. It is the one I referred to. I know it very well. I could probably recite it in my sleep. And the Justice, as I said, was giving a 360-degree view of licensing, because that is what it is. It is not the exclusive purview of one contingency or another. It is a fully rounded view of what is reasonable and appropriate in accordance with the views of many people. And faith in strangers is not as it is being characterised here. It is absolutely fundamentally rejected that the business model has changed in any way or shape. And I don't hear the authorities claiming that to you. You have not had a representation from the licensing authority saying all bets are off, everything's changed, nor does environmental health say that to you, nor does planning. The police have not said anything. That is the position of your responsible authorities, and the Section 182 guidance makes it very plain that you take your expert advice, your expert input from your experts, and should be primarily and fundamentally guided by what the professional witnesses and responsible authorities say to you on those specific points. There have been COVID lockdowns, which might have had an impact on the output from the business. Other than that, it has been absolutely continuous, including DJs, including music, including everything that it was always designed to achieve, because it was never going to be viable without it. And as you can imagine, competent business people do their business models before they open. They don't change tack part way in, and certainly not in such a short period as 2 years, to realise they've made a terrible, terrible mistake and they're not going to be able to make a profit out of poetry. That is not what has happened here by a long shot. That the residents and Mr. Rees-Gay on their behalf tell you that this is a public nuisance. Environmental Health have put it in writing that it is not. And for that reason, they have withdrawn the noise abatement notice and the review, because it is not, after their independent investigations, a noise nuisance. For you to find otherwise, based on what residents are telling you, would be a very big and, may I say, dangerous step indeed. I have objected to Mr. Ranatunga presenting the review application to you, which I maintain he has in fact done. That's a legal error and shouldn't have happened. But in any event, that is what you have in front of you, and that investigation, that review application, terminated with a withdrawal and a letter expressing the absolutely outright conclusion that there was not a public nuisance. And what you cannot do is now make a decision based on speculative future concerns that Environmental Health might have, upon which there is not a shred of evidence before you. Mr. Ranatunga updated you, again, entirely wrongly, and outside the purview of any application that had been put before you or any representation. I maintain Environmental Health are not actually technically here, but it was quite wrong for him to indicate to you in generalised and vague terms what might be happening with Environmental Health now, and without readings, without site visits, without officer notes. You have no clue as to what that situation is, and to base a decision upon it at this stage would be entirely wrong. I'm not clear, and my final point, I'm not clear what it is you are being asked to do. I don't know what the relevance of 11 o'clock is said to be. Why that hour as opposed to any other? Curtailing the hours for these premises, as they've made very, very plain, is tantamount to a revocation. And there mustn't be any doubt about that. Cutting the hours back is the same thing as terminating the business. They cannot and will not survive on hours other than those that they put in for and were granted. In terms of putting in a noise limiter, the Environmental Health Department don't ask for it. You would be imposing something that Environmental Health do not ask for themselves, and on the basis that they would be the ones expected to marshal and administer it, that creates a complication in and of itself. And then finally, conditions as to the specifics of hand dryers and rubber feet on chairs. Firstly, it's been done already, and secondly, I don't know how you would word a condition like that. I've never seen it. Never seen it done. And if the residents saw fit to invite you to do so, one might have thought that they would draft a condition for you to consider in advance and for us all to comment upon. But my strong contention to you is that it simply isn't possible. Unless I can help you, that's what I'd wish to say.
Thank you, Ms Clover. Mr Randall, Mr Duffy and Mr Ford, are there any final comments you'd like to make?
Yeah, I'd just like to reiterate that the last comment, or towards the end of what Sarah said, it will essentially close us down if that happens. We've invested nearly £500,000 into that property. It was a derelict site. It's one of the most prominent buildings in Cliftonville, and I firmly believe that we're a positive part of the regeneration for a wider community. We employ mainly local people that grew up in Thanet. We're training them to open their own businesses. We've got numerous workspace people that rely on us for their mental health as well, particularly during COVID. A lot of them have moved down here by themselves. Loads of them have said they would move back out of Margate if we close down, and that's in our letters. And yeah, I mean, I just hope hope that those restrictions aren't put upon us, because that would be the end of us, basically. That's the end.
Chair, sorry, could I just clarify? EHO did say a noise limiting device, and that was on page 14. Ms. Clover said it wasn't.
No, I didn't. If Mr. Reesco would listen so very carefully to my submissions, I said that they have withdrawn their application. They are no longer asking for it.
Apologies.
Is that all clear now? Okay, good, thank you. Okay, so thanks very much. The committee members, Democratic Service Officer and the Legal Officer will now leave the room to make their deliberations, and we will return back to the Council chamber for the decision to be announced. So back in about half an hour. Hello again. I'd now like to invite Ms Phillips, the Principal Litigation Solicitor, to read a summary of the subcommittee's determination.
Thank you. In the application for a full review of the licence for Faith in Strangers, 17 Ethelbert Crescent, Margate, having considered documentation and representations made to the board on the 17th of February and considered representations from the Licensing Technical Support Manager, the report she gave, the Licensing Department from Mr. Ranatunga for the Environmental Health Department, representations from the interested parties who were represented by Mr. Rieske, and from Ms. Clover for Faith in Strangers. I would say also that it wasn't an easy decision that was reached by the committee. The committee considered the steps that may be taken further to Section 52(4) of the Licensing Act, which includes steps such as modifying the conditions of the licence, excluding a licensable activity, or removing the designated premises supervisor, or suspend the licence for a particular period of time, or to revoke the licence. Now, these are the steps that may be taken further to an application, which has been made by a responsible authority or any other person. On this occasion, the application to review the licence has been withdrawn, and the subcommittee accepts that withdrawal, having been assisted by the representations that were made by Mr. Ranatunga for the Environmental Health Department. The subcommittee have been greatly assisted by the representations made by the residents and their representative. However, in the absence of an application by another person in accordance with Section 51, the subcommittee are unable to take the steps provided by Section 52. Those representations have enabled the subcommittee to give proper consideration to the reasons given for the withdrawal of the application to review. The application to review is withdrawn, and there can be no review of the application further to this hearing today. The subcommittee do make various recommendations which expresses that they recognise the competing interests of both parties, which include to add to the local economy and the well-being of the residents, and recommend steps to be taken for all the parties to collaborate in achieving a resolution to the soundproofing issues that emanate from the premises. And secondly, if this is not achieved, the relevant authority or the other party should make an application for a review if it's deemed appropriate based on the evidence. And that's the decision of the subcommittee today.
Thank you. And that's the end of the meeting.